get set up on the
Get set up.
Thank you. Sell out there is our little expert.
Yeah, I like this kind of stuff.
Well, as I mentioned, this is close, I'll get to a bench. But I want you to know that we have an unbelievable group in this panel discussion. Tremendously skilled folks. Wendy Alderson is a genetic consultant with an incredible background. Rod, who is not standing there right now, who will be coming in, is the one lawyer, my friend from Orange County, who was a high-level dude in the crime lab and told me to come and meet when I got out here. Rod Soda has been through it, been through the DA's office, and he's tried heavy cases. He's a hell of a nice guy. Sheila is my friend from law school. I didn't know Sheila personally in law school, I just knew who she was because you couldn't miss her. And we went around as young lawyers and talked to the DAs and begged for deals. And then she disappeared. I didn't know what happened to her. And I came out here and here she was, 20 years later. And she is the known heavyweight in the family law business out here in this area. And she says she's retired, although you shouldn't believe it. And Dale Wells
Semi-retired.
was the head guy in family law, FLAP, whatever they call him.
Yes, when I was Family Law Assistant Center, yeah.
Assistant Center. He's been a judge on the bench out here for how many years? Many years.
19 years.
19 years. I tried a few cases in front of him, and it was quite an experience. And he's now sort of retired. Sheila and Dale have a mediation service for family law issues, which is a tremendous thing because you know how nasty people get it and how they need some help with settling problems. And here's Rod now. So, you guys. Dave, are you there now? We can't see you, we can only hear you. Why don't you call Dave Moore?
Just start.
All right, well, I'm just saying, go call him and tell him to come on with this video. So we can talk to him. All right, Rod, go ahead, kick it off.
Thank you, John. Hi, everyone. I don't know what John said about me, but I'm sure it's not true. How many of you have ever attended one of these programs where I've been the speaker the last few years? No. Okay. So most of you have attended the seminar for the topic that I've handled for ethics, which has been some of your clients will go to jail, don't go with them. And it's always been geared towards a civil practitioner because they're the ones who are not aware of the rules for criminal law and the ones who often get in trouble. This is a different program. Today we are doing a program on reporting requirements and reporting requirements under the state bar rules of the Business Professions Code that we're going to be dealing with. Judges' responsibilities for reporting lawyers who screw up. The lawyer's responsibility for reporting himself. And the third is the responsibility of other lawyers to report lawyers who screw up. And for criminal defense lawyers, most of us refer to that as the snitch rule. But for purposes of today's presentation, we are going to deal with it from the State Bar and the Supreme Court's view, which is, in essence, a review of the Girardi rule, which is something that Dale Wells will address to you now. Dale?
Who likes a rat? Who wants to be a rat?
Stitches, good stitches.
That's right, snitches get stitches, absolutely. We don't like rats. I don't like them, you don't like them. We don't want to be one, we don't want to be known as one. But what happens when you don't have a rule? We have what we call a snitch rule. What happens? Well, let me tell you about a lawyer. You may recognize the name, you may not recognize the name. Did you ever watch the movie Erin Brockovich?
Yes.
You remember the story about the tainted water supply and the $333 million settlement with PG&E?
Yep.
Well, the fella who handled that case was a fellow named Thomas Girardi. firm of Girardi and Keefe. And he served on, he was inducted into the Trial Lawyer Hall of Fame. He was named Lawyer of the Decade in 2018. He served on Governor Newsom's Judicial Selection Advisory Committee, which says that he actually passed on me becoming the judge. Sounds like a pretty good guy to me. Behind his public persona, Thomas Girardi operated a decade-long fraud scheme that exposed catastrophic failures in California's attorney discipline system. From 2010 to 2020, Girardi stole over $18 million in client settlement funds. He stole them from the most vulnerable people. I mean, he's not stealing from people that have the resources to come after him. He's stealing from folks that this is their money that they need to live on. People that had suffered plane crashes, their families had been injured or killed, people who had been burned in fires, people who were widows, cancer patients. Here are some examples. The Lion Air crash families, he stole $3 million from 5 families. And when they asked him about payment in May of 2020, he said, "I think you'll love me in 30 days, as he was taking $3 million home. San Bruno explosion victim. He got a $53 million settlement from PG&E for Joseph Rui Gomez, who was burned over 90% of his body. And he told him this $53 million settlement was only $7.25 million. He embezzled $26.5 million from him. Car accident family kept $15 million of their $17.5 million settlement. He concealed the amounts of the settlements, he fabricated payment delays, and he used Ponzi schemes. He bought private jets, luxury cars, jewelry. He spent $25 million to fund his wife, Erica Jane's entertainment career. If you ever watched the Housewives of Beverly Hills, you probably saw him on that. Over 40 years, State Bar received 205 complaints about him. 120 complaints involved client trust account violations, 0 public discipline. In fact, he wasn't even investigated until 2022. February 2023, an investigation opened, and they discovered that he had systematically bought influence. He employed children of State Bar employees in his firm, Girardi and Keefe, which no longer exists. He provided concert tickets, meals, and luxury travel to bar officials. He hosted lavish parties for bar personnel. He was godfather to the child of the investigator for State Bar. And in fact, he paid his family, Tom Layton's family, over $1 million. 2 employees with Girardi connections worked on his cases. And those cases, surprise, surprise, were closed without discipline. So, the State Bar finds out what's going on. February, they start an investigation. March 2023, 1 month later, State Bar acknowledges persistent institutional failure and a shocking past culture of unethical and unacceptable behavior. February 2023, he's indicted for wire fraud in Los Angeles and Chicago. August 2024, he's found guilty at trial, despite the fact that he has Alzheimer's dementia, and he uses that as a defense. June of 2025, he's sentenced to 87 months in federal prison, a $35,000 fine, which sounds a little bit light to me. $2.3 million restitution. July 2025, he began serving his 7-year sentence at the age of 86. So, that's the background for the snitch rule. Why do we have a snitch rule? Because of what happens if we don't have a snitch rule. And I was surprised to find this out. California was the last state in the country to develop a snitch rule. Every other state in the country had one. And we kept saying, we don't need it, we don't need it, we don't need it. But the Girardi scandal prompted reconsideration. The California Supreme Court approved the rule on June 21 of 2023. Now remember, investigation February, State Bar acknowledgement of their failures March, June 21, 2023, the Supreme Court approved the rule, it became effective August 1. So we fast-tracked it. Now, what Rule 8.3 requires is that an attorney report without undue delay when you know of credible evidence that another lawyer committed a criminal act or dishonesty, fraud, deceit, reckless or intentional misrepresentation, or misappropriation that raises a substantial question about the lawyer's honesty, trustworthiness, or fitness. There are some exceptions. Confidentiality, attorney-client confidentiality, information from a substance abuse program that the attorney might be in, attorney-counselor consultations, and reports to the state bar are privileged. So, the report is made online on the state bar online form or made to the appropriate tribunal, the tribunal that's handling the case that's under consideration. There are some things that are prohibited. You cannot enter into an agreement that if you do this, I won't report you. That itself is a violation of the rules of professional conduct. Now, why does all this matter? Well, it goes back to 1988. In the state of Illinois, there was a case called N. Ray Himmel, where an attorney was sanctioned for failing to report a colleague's $23,000 client fund conversion. His client told him, don't report it. He and the other attorney entered into agreement not to report it. He failed to report it, got caught, and he suffered a 1-year suspension because of that. Ever since then, the very next year, Illinois' misconduct reports increased 498%. There's something about knowing that people are looking over your shoulder and they're going to be watching to see if you actually are doing what you're supposed to do. What are practice implications? Well, effective since August 1 of 2023, no California discipline cases have yet been reported because obviously it hasn't been around that long. But there are some real obligations here. You need to assess whether the attorney's conduct meets the substantial question threshold. You need to report without undue delay. Those are key words. Once client prejudice concerns are resolved. You never enter a settlement agreement prohibiting reporting. We're going to talk about Rule 8.3, which is going to be the focus of our discussion today. And if you have questions about whether you have an obligation to report, you should consult ethics counsel to see whether you need to report. But remember, failure to report of things that are required to be reported can itself be a reportable offense. So the Girardi scandal exposed how regulatory capture, lack of mandatory reporting, and compromised oversight enabled 40 years of misconduct by this one lawyer. Victims were re-victimized, first by their tragedies, then by their attorney, and finally by the state bar that ignored them. So we can just never let something like that happen again. Rule 8.3 is mandatory. It's not aspirational. It's not something we're supposed to, aspire to. It's absolutely mandatory for us as lawyers. No future attorney should ever operate with impunity while regulatory systems fail to act. So that's a kind of a synopsis of Girardi. I'd suggest this. The next time you have, 4 or 6 hours free, just Google Thomas Girardi. It'll take you a while to get through it. When I wrote notes, it was 23 pages of notes that I took that I just summarized. Jackson?
Can I ask you a question?
Mm-hmm.
I know Girardi. I tried cases against Girardi. And I don't get how Girardi's conduct came up with a snitch rule. It seems to me that the problem with Girardi and his taking other people's money had to do with the state bar and corruption in the state bar and Girardi. How would another lawyer outside of his firm know about that?
Well, when you look him up, you'll find out that...
Can other lawyers use that as leverage against you?
No, absolutely.
I mean, they're not supposed to, but I guarantee you they will.
Well, okay, that's reportable also, and we're going to talk about that. The attorneys in his firm were aware of it. The attorneys who were employed by his firm, who were family members of the state bar, were aware of it. There were other attorneys aware of it. Now, I agree with you. The state bar is the one that dropped the ball. But you know what? Maybe we need to be looking over the state bar's shoulder to make
That's
sure
what
they're doing
I'm,
what they're
that's what,
supposed to do.
Judge, that's my point. We need to look over the state bar rather than lawyers looking over lawyers. How about looking over the state bar and that they do their job?
Well,
Had they done their job, Girardi would have never been able to steal all of that money over all those years.
205 complaints over a period of 40 years, 120 of them dealing with misappropriation of client funds. Some attorney somewhere knew about it and didn't say anything.
And I think to further emphasize that point, we as lawyers have been practicing 45 years. We know of very few lawyers who have ever been reported to the state bar for behaviors that we might on our own consider to be egregious, reportable, sanctionable, but it's really never been the situation. Last year, Dale and I did a presentation where the state bar now requires an area called civility. Never was required before. And there was a lot of uncivil lawyers out there. So last year, the state bar made a requirement that you have to have 1 hour of your 25. So the point is that I think what these rules do for me is, and why I present these seminars and participate, is that it makes us aware that we have these ethical obligations. No matter how you feel, we all know people. I was preparing for this, and I thought of about 3 or 4 people I could probably snitch on right now. Because the result of which is Girardi's behavior goes on for decades. People know, and nobody does a thing. And he's powerful, so we don't do anything about it. So I think these are very important, especially with this new generation of lawyers coming up, that they need to be aware that there are certain ethical obligations. And by the way, if you make a false claim, and we'll go through that in the material, you can be sanctioned for that. So people would be reluctant, right? You'd say, well, if I do something and the state bar does nothing, then they're gonna come after me.
What bothers me is if a complaint is made and it's not a legitimate complaint, it destroys the attorney's life against whom the complaint is made. I agree with your civility. I had a case where the managing partner in a medical malpractice firm, and I represented the plaintiff, and his conduct was totally it was anything but civilized. And he was a member of the American Board of Trial Advocates. I sent him our preamble about ethics and being ethical and courteous to your adversaries. He never spoke with me again because he was so unethical and so not courteous and professional. But I agree with this being courteous and all of that. Well, I think it opens a whole can of worms when lawyers start reporting lawyers, because the lawyer that the report is made against, he's damaged. He's got to hire a lawyer, an ethics lawyer, pay a lot of money in attorney fees for something that may not even be biased or be based on fact.
So what you need to do is you need to stay as far away from the ethical line as possible, rather than walking as close to it as you can.
I totally
In fact, thinking about Girardi and thinking about this 40 years of failure on part of the state bar, I agree with you, it's on part of the state bar. But remember, every other state has had this rule, and when you go back and look at the cases that stand out about snitch rule, there are 2 of them. Himmel from 1988 in Illinois, the very next year after that happened, 498% increase in reports. You don't see any more discipline as a result of snitching anymore. You don't see it in any other courts, but you get to California where we've said for 40 years, we don't need it, we don't need it, we don't need it, it ain't fair. I don't want to be on that. And look what happens. I mean, we have to police ourselves because we're members of the state bar.
right.
So we have to police ourselves.
Can I just raise one quick? The question that you raised was what is the state bar doing to help police? And the CCAP rules, which are now in place with respect to trust accounts. The rules go so far now as to say, if you are an associate in a law firm, not a partner, don't have an economic interest other than your salary, and you represent a client of that firm who has money in trust, it is your obligation as the associate to inquire of the partners about the status of that trust account regularly, and to make certain that when funds are put in trust for delivery to the client, that they are in fact delivered within 30 days under the new rules. So, the state bar is taking steps, of course, to making all the rest of us sweat. But, if you have a trust account these days, you're going to perspire just like you were a kid in a spelling bee.
And by the way, we didn't have that reporting requirement with the state bar until about maybe 5 years ago. Now there's a specific form when you pay your bar dues that asks you the name of the bank, the routing number, the account number, how much is on deposit at the end of the year, when you open that account. I actually have to go back to my bank and find out when I open an account. I've had one for years, but I had to go back and all that detail was required. It wasn't required before. And one other point I want to make, which is a little bit, not ethics, but in that civility realm. You know, judges have had opportunities to deal with uncivil matters. And there was a case that we reported in our last seminar where not only was the issue of civility brought up, the lawyer's pocketbook was affected. The lawyer made a request for attorney's fees, okay? Let's say $100,000 hypothetical. Because of the uncivil behavior, the judge reduced the attorney's fees to like $20,000 because of all the things that this lawyer did as an uncivil lawyer. And by the way, that was why the rule became the rule last year that we now have to do civility. But when you hit the pocketbook is one thing, you know, these rules are about, we can take your bar ticket. And all these civility rules, they say, we can hit your pocketbook. You know, you thought you were gonna get 100 grand in fees, maybe we'll give you none, we'll give you a smaller amount. And does that change people's behaviors? I don't know. These rules are too young for us to see a historical place in how that plays out, but I think that we all know of these situations, and it's an honor for me to be a part of this, because I learn every time I come in here and do something, and you guys give us great stories that you've heard, we share stories that we know of. But we need to police ourselves, and we're not going to, because nobody's ever held us accountable, right? Every time I pay my bar dues after 45 years, I go, oh God, I just made another year.
I love the civility aspect, I think it's great.
Yeah, it's great. We'll probably be doing another presentation this year.
And I completely understand what you're saying about not wanting to have to snitch on opposing counsel when you don't really know for sure all the details, but I think what really hit me in the Gerard case was that everybody in this firm knew it.
Right.
That he was getting away with this for years before the state bar even investigated. So yes, we can be angry at how the state bar let everybody down, but all the people in his firm that were watching him steal millions from their clients and not doing anything about it, I think makes this rule absolutely necessary.
Well, they all of them had to know.
Oh, yeah.
The office building, the Worcester Boulevard, they all had to know. They all had to know about the private jets he was buying, the casinos he was buying, and wonder where that money came from, so.
Okay.
Thanks, Dale, appreciate the primer.
I told him it was only 2.1 million in restitution.
I
Yeah,
know
right.
those numbers are way
The
low.
restitution was nominal in comparison to the charges, yeah.
All right, if any of you attended NCLE programs where the three of us have been involved, especially with a group as experienced as the group we have here, what we do is make it very interactive. We're going to raise a series of hypotheticals. We're going to ask you your thoughts about them. We'll give you more input on the law, and then we'll ask you to comment again. We want this to be an interactive experience so that we don't have to do it before. All right. It's a long one, so I'm going to read it. Family law court judge presided over a hearing between the parties where the respondent husband sought a substantial reduction in court order. The respondent husband, through his attorney, filed income and expense declarations, testified in deposition, and then testified in the hearing that he worked for witness A, a general contractor, part-time, and had no other source of income. The petitioner's wife, attorney, puts witness X, a different general contractor, on the stand to testify that respondent has worked for him on the average of 60 hours per month for the past 2 years for cash under the table. Neither this fact nor the income from that employment with witness X was ever disclosed by respondent or his attorney in the pleadings, filings, discovery, or hearing. When the court asked the respondent's attorney whether he was aware of the second job, the attorney did not respond, despite the court repeating the question more than once. The court citing 1209A3 Code of Civil Procedure as grounds cited respondent attorney with contempt. A hearing went forward, section 1211A and B, and after proper notice and the hearing, found that the respondent attorney was in contempt of court. The court suspended proceedings for the purpose of granting the attorney probation for 1 year on condition he satisfied 100 hours of community service. Adding to that hypothetical, assume further that immediately after the ruling, the respondent's attorney filed an appeal. All right? So, based on these facts, does anyone here believe that there's been an ethical violation of the law?
Yes, well, failure to disclose, he was supposed to disclose if he knew,
Okay?
or had reason to know, he was required to disclose the earnings.
Right. If it's an act of misconduct, then it should be something that's reported, is that right?
Right.
All right. Rule 8.4, the rules of professional responsibility. It is professional misconduct for a lawyer to violate these rules of the State Bar Act, knowingly assist, solicit, or induce another to do so, or do so through the acts of another. And B, commit a crime, criminal act that reflects adversely on lawyers' honesty, untruthfulness, or fitness as a lawyer in other respects. Let's talk about criminality issues. At the very least, assuming that the lawyer knew, is he not supporting perjury?
Yes.
Which would be a criminal act for which, under the rules, there should be reporting, probably. But clearly, supporting perjury would be an act of misconduct, all right? In addition to going to Rule 3.1, meritorious claims and contentions, a lawyer shall not, A2, present a claim or defense in litigation that is not warranted under existing law unless it can be supported by good faith argument for an extension, modification, or reversal of the existing law, or 1, bring or continue an action, conduct a defense, assert a position in litigation, or take an appeal without probable cause and for the purpose of harassing or maliciously injuring any person. So under Rule 3.3 or 3.1A, 1, has the attorney not done that here as well?
Yes.
Okay, so given the finding of contempt in this case, should there be a report made to the State Bar? Who disagrees? Who says there shouldn't be?
Well, let me stop you here for a minute
Yes.
on these facts. Okay? We saw the first hypothetical. Is the lawyer aware of the second job based on this hypothetical, this first hypothetical? What it says in the facts is that he had worked for another contractor under the table, but it says neither this fact nor the income from that employment with witness X was ever disclosed by a respondent or his attorney. Did the attorney know at this point? Because that's where the suborn and the perjury comes in. When he knows it and then he puts his client on the witness stand and he testifies contrary to that. So I'm just playing devil's advocate here because those are some of the things that when you want to charge a lawyer, you have to show that that lawyer had that knowledge.
How many of you guys have ever had a client lie to you?
As a matter of fact, I had one that lied to me about a very important fact in the case, and I fired her. I refused to put her on the stand. I would be suborning perjury. I was not going to get involved, and I said to the client very clearly, I can't do this. Well, but they don't know. I said, my bar ticket means a whole lot more to me than this issue that you have before the court, which is financial. So once you know that information, so I'm just saying, in this hypothetical, we've got to attach knowledge to that client.
Can I respond?
Please.
It would seem relevant to me the next sentence. So when the court asked to respond, and the attorney
Yes.
he knew,
He didn't answer.
he didn't answer it twice. So what's the legal implication of that?
I got you. But if we're gonna
No,
discipline.
that's what's the answer.
No, I agree with you, but I'm saying,
Oh.
if you're gonna have discipline, I need to have proof positive, right? He didn't answer, I mean, that's kind of, you say nothing, so you must be guilty. Well, I don't think the law works that way.
Oh, that's what I was
We can
asking.
make
What
that-
is the legal implication?
Right. We
Asking
can make that
twice
inference.
with no answer.
But I think that at the end of the day, there is no affirmative statement by the lawyer that he knew.
Yeah, you'd be hard pressed to make a finding of contempt based on the fact that the lawyer was silent. He doesn't have to testify against himself.
Okay, that was my question.
And that was probably his way of getting around that communication, of course, but that's the position he took. I'm not talking. He didn't take the fifth, by the way. He just didn't answer the
But
question.
if his documents said he only worked for contractor A, and his wife's declaration said he worked for contractor B, and took under the table, didn't they have to shade documents, and wouldn't that have made the lawyer aware of it? Or at least aware of that declaration?
Well, yes and no. What it says is that the petitioner's wife put on that witness.
Okay.
So, I'm a family law attorney. Okay?
No.
Maybe they don't know what that witness is gonna say until they get on the stand. We're normally required, when we put a witness on the stand, to give a summary of what they're gonna say, but if they're used for impeachment purposes, you don't say anything. You ambush them right on the stand. So now the lawyer's still in there.
It's hypothetical was phrased the way it was, but the lawyer doesn't answer. And the reason is, when we break down the discussion about the judge's responsibility, the lawyer's responsibility to self-report, or the other lawyer's responsibility to report, part of that involves the deliberation for the thought processes to determine whether or not these people should report.
Right.
Okay? In this case, there's some ambiguity. The fact is, the lawyer did not admit he did it. And you'll learn from Dale, and you'll learn from Sheila, under the state bar rules, the canons of judicial ethics, what the requirements are for the judges and the other lawyers before they make that big step of reporting somebody to the state bar. All right? So, at this point, we'll bring up Dale to discuss the judge's responsibilities under the judicial canons and the business professions code.
Okay, thank you. All right, well, Judicial Canon 3D2 says whenever a judge has personal knowledge or concludes in a judicial decision that a lawyer has committed misconduct or has violated any provision of the rules of professional conduct, the judge shall take appropriate corrective action, which may include reporting the violation to the appropriate authority. That gives the judge a lot of latitude, especially on a case where he can't make this, a firm determination that this attorney's committed perjury or misrepresented things to the court intentionally. So what are some things the judge can do? Well, the judge could set an OSC and let the attorney have an opportunity to prepare an answer for it rather than just springing it to the court. The judge could disregard the testimony of the respondent who says this is all the money I make, and his witness says this is what I pay him, and certainly include the testimony of the wife's witness, who's going to say no, he makes this much money as well, and so that's going to affect the amount of dollars that's going to be paid in support. But notice that the judge is not required to do that unless there is an actual finding of some wrongdoing on the part of the attorney. The advisory committee commentary says that you have to look at, the judge has to look at Business Professions Code 6086.7. Incidentally, the legislature loves playing with our dyslexia. 6068 sub A through O is all about self-reporting. That's 6068. 6086 is about the court reporting. So whenever you see those two numbers, if one of them doesn't fit, just reverse the last two digits. So a court shall notify the state bar of any of the following: a final order of contempt imposed against an attorney that may involve grounds warranting discipline under this chapter. So even though we're left with the court has to take appropriate action, the court may report, but 6086.7 says the court shall report if there's a finding of contempt. Whenever a modification or reversal of judgment in a judicial proceeding is based in whole or in part on the misconduct, incompetent representation, or willful misrepresentation of attorney. So if the judge concludes that the attorney willfully misrepresented things, then this is mandatory reporting. The imposition of any judicial sanctions against an attorney except sanctions for failure to make discovery, which arguably this might be since it's a matter of disclosure, or monetary sanctions of less than $1,000. There's also Business Professions Code 6086.8, which says within 20 days after a judgment by a court of the state that a licensee of the state bar of California is liable for any damages resulting in a judgment against the attorney in any civil action for fraud, misrepresentation, breach of fiduciary duty, or gross negligence committed in a professional capacity, the court which rendered the judgment shall report that fact in writing to the state bar of California. So for myself, when I'm left with, on the one hand, the judicial canon says I may report, but the Business Professions Code says I shall report, guess what I'm going to do? I'm going to report. Because I don't want to be home. Because what happens if I don't report? Well, someone might say, well, what's the penalty for a judge that doesn't do what they're supposed to do under the rules of professional conduct? Well, the can you think of the name right now? Commission on Judicial Performance. That's the one I had Jenny stuck in my head because I wrote a letter about an attorney yesterday. Commission on Judicial Performance. They can discipline a judge for failing to report when they are supposed to report. Are they likely to do that if that's the only charge against them? Not likely. When you look through the record of the CJP reports, you're not going to find any indication that anyone has been publicly reprimanded or publicly disciplined for it. But that doesn't mean that they weren't disciplined with an advisory letter or a private admonishment, something like that that wouldn't show up in a public report. So it's quite possible that there are judges who have been disciplined, but the discipline is private, not public.
Thank you. My topic is talking about self-reporting. Unlike the most recent Rule 8.3, which Sheila will talk about, self-reporting by lawyers has been a requirement for many, many years. There are two forms of self-reporting. Those where the lawyer should do it, and those where the court, where the lawyer, the offending lawyer, is mandated to do it. Under Rule 6068, 1 through 10, outlines those circumstances where a lawyer must report and must report immediately if there's been an act he committed, an offending act, which requires reporting under the state bar rule. And some of the more important ones, filing a 3 or more lawsuits in a 12-month period against the lawyer for malpractice, an entry of judgment against the lawyer in a civil action for fraud or misrepresentation or breach of fiduciary duty, imposition of judicial sanctions against the attorney, except for sanctions for failure to make discovery or monetary sanctions of less than $1,000. There are many more, but under 03, here where the judge has issued an order of contempt, that lawyer is obligated to make his report. Okay? Now, I keep the hypothetical number 2, which was the lawyer files an appeal. Does the appeal stay the reporting requirement of the attorney to report that he was held in contempt by a judge? What do you think? Anyone? Cameron?
Well, I just want to make sure I understand the chronology. There, he files the appeal, the waiting time, is there not, before doing anything?
No, that's the question.
That's the question.
When you file the appeal, what's your obligation? Must you report now, or is there a timeline? That's the focus of the question.
I would think one would be now, why wait for appeal issue?
Well, you can't wait for, I mean, how long is an appeal gonna take, guys? What, a year, 2, 3? So you get to wait?
And in this particular case, the judge didn't actually sentence him.
Okay.
It was like a criminal case where they suspended proceedings for the purpose of granting probation.
All right.
So has there been a judgment? Well, the answer to that one is simple. There has been purposes of appeal. So the question is, in this case, the lawyer files an appeal and admittedly to delay having to report to the state bar. Can you do that? And does that state proceeding? Pete, what do you think?
I don't think so. I think you, unless explicitly in the language of the statute, it says within 30 days of the judgment, and I haven't read the statute, so I don't know, without it saying something in regards to appeal, I don't think appeal would stay. I think just a better practice would be report and maybe report along with that. Oh, and by the way, this is on appeal. State bar, take that into consideration before you take any further action. And it's on record. You've complied.
Well, remember, the state bar is gonna start an investigation. They're gonna be aware of the appeal.
Right.
Your obligation is to report.
Right.
And the answer from a judicial perspective is in 6086.7A, a final order of contempt imposed against an attorney. So, this is a final order of contempt. It may be set aside by the Court of Appeal at some point, but at this point, it's a final order of contempt. So I think the judge has to report.
So we know from a judicial standpoint, there's no stay for the filing of appeal. How about for other attorneys?
Well, let's go back to the original hypothetical, which is the self-reporting. Do I have to snitch on myself to the state bar when I have an appeal pending against the contempt? And the answer is yes. The time is what, 30 days?
30 days.
Within 30 days. Same thing with, and I'll do the next section on my obligation, and I picked that one because I like it better, because there's a lot of people I like to turn in. Family law lawyers, great for doing stuff. I would think you have similar rules, that I must report that within a 30-day period to the state bar when they've been found and held in contempt, whether they appeal it or not. Because we don't know the ultimate outcome of an appeal. We know that most appeals are not granted, but that doesn't stop the information from being given, because that's really what ethics are all about. If somebody took the time to report it, the state bar will investigate. We don't know how long that takes, but they should know that. And if it's something very egregious, then do we want that lawyer still out there practicing law? Like Girardi for 2 decades? No, we want somebody to stop him, right?
And for purposes of self-reporting, the answer is still no. And the opinion in that matter is in re matter of respondent Y at Retail State Bar Court Reporter 862-866-867. You're not allowed to delay proceedings by filing the appeal. So now, going back to general discussion about reporting others.
Yes.
Sheila?
Good. Screen's a little short, I have older eyes, I have glasses, I need to go over here, sorry. Attorney's duty to report others. Those are your colleagues, the people you deal with all the time, that you see and interact with primarily, because that's where you're going to get your information. And the rule that applies is 8.3. Became effective August 1 of 2023. And as we said earlier, it's interesting to note how many years has it taken for these rules to be put in place? Because I've been a lawyer for 45 years, so I haven't been under this rule except for 3, so not bad. I got 42 good years. Do anything. Anyway, the following is the basic provisions for an attorney's duty to report others. California Rules of Professional Conduct, Rule 8.3. It's in your materials. A lawyer shall, you don't have any discretion, without undue delay, inform the state bar or tribunal with jurisdiction to investigate an act upon such misconduct when the lawyer knows of credible evidence that another lawyer has committed a criminal act, and that's defined further in section C, or has engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds or property that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Subsection A, shall. Now, we all know, and I'm a law school professor as well, for every rule there's exceptions. And this is no exception. There are exceptions. So, B, a lawyer as required by paragraph A, except as required by paragraph A lawyer may, but is not required to report to the state bar a violation of these rules or the State Bar Act, may. So you have subsection A that requires, and subsection B says here's the exceptions, and here's what they include generally. Looking at section B. Well, C defines criminal act. So criminal act excludes conduct that would be a criminal act in another state, but would not be a criminal act in California. So if you go to Nevada, you commit a criminal act, but it's not a crime here, it's not reportable. And section D gives you the exceptions. Information gained while participating in substance use or mental health programs. We want to encourage people to do those things. Mediation, confidentiality. Dale and I do mediation. They're private. There's a whole bunch of rules that talk about mediation confidentiality. Can't use that. It's an exception. Lawyer-client privilege. Something between you and your client is exempt from this rule. And other applicable privileges or other rules of law, including information that is confidential under the Business and Professional Code, section 6234. So we have the shall portion, then you have to snitch on your colleagues, then you got the mays. And we'll talk later about the ramifications of either not doing that or doing it in a bad faith way. I mean, there's some lawyers that I don't like. I like to go turn in. But if I do, I would have credible evidence. I could be in trouble.
But Sheila, it says shall inform the state bar or a tribunal.
Right.
How does that play?
So what's the tribunal? What are the options for tribunals? Anybody know? What's a tribunal other than the state bar?
The court hearing the case.
Exactly. Sorry?
The court hearing the case.
Exactly. Exactly. Very good. So you have some options, but the whole idea of ethics is to make sure that we keep these matters in check so they don't get to the place where they get out of control and or potentially hurt your clients and maybe affect your future political career.
And look at your comments, because the tribunal has to be one that has investigative authority.
Right.
For instance, arbitrators don't have that, so you can't treat an arbitrator as a tribunal for purposes of the reporting rules, okay?
Right.
Hypothetical number 3. Assume same facts as hypothetical number 2. Assume further that respondent's attorney is licensed in California, but this trial occurred in the state of Florida, and it's not in California. Assume further that the respondent's attorney is either licensed in Florida or was given permission to try this one matter in Florida pro hac vice.
So how many of you guys have ever done a pro hac vice case? That is, you're licensed in California and you go to some other state. I've been to New York, I've been to Connecticut, I've been to Texas, I've been to Arizona.
I've been to Arizona and Nevada.
It's kind of cool.
In Wichita and Alexandria, Virginia.
Yeah.
I hired a lawyer in Connecticut to be my pro hac vice guy there, and of course, I do the work, but he has to introduce me to the court. So the day of the hearing, I show up, right, I'm there in a hotel with my client, and he ain't there. And I call his office, and go, dude, what's up? He goes, oh, I thought the trial was tomorrow.
My first trial in Arizona, I was scolded the first day because I didn't realize it was a time change.
That's good, that's good.
Does the fact that the act and the finding of contempt occurred out of state prevent California from doing anything about this? What do you think?
No. I mean, California still should be able to take action.
Okay,
Remember the California bar?
He's a California lawyer no matter where he is. Or she.
So does
Or
Rule
she.
8.5,
does the rule give a state bar jurisdiction?
yes.
And
Rule 8.5 provides a lawyer admitted to practice in California is subject to the disciplinary authority of California, regardless of where the lawyer's conduct occurs. A lawyer not admitted in California is also subject to the disciplinary authority of California if the lawyer provides or offers to provide any legal services in California. A lawyer may be subject to the disciplinary authority of both California and another jurisdiction of the same conduct. The only exception is if you're convicted of a crime in that other state, but it is not a crime in California, then it's not actionable by the California State Bar.
Correct.
Hypothetical number 4.
Just a quick question.
Yes.
On that last point,
Yeah.
what would the state bar do for an attorney who does something from another state who violates a rule? Like, what would the state bar do to that attorney? They don't really have jurisdiction to void his license or anything.
Well, if the other attorney's licensed in California to practice, they can add.
Of course.
If the other attorney does
Just
something in
providing
California where he's not licensed, he can be prosecuted for practicing law without a license, criminally.
But if he's operating under pro hoc vitae, then the court could take action.
That's right.
So here's another hypothetical in that regard, and it's this. Lawyer licensed in Louisiana, not licensed in California. Does work in California, kind of as a lawyer, little quasi-lawyer stuff. Not a lawyer in California. What does that tell you? California, he's not licensed in California, he's licensed in another state. But he's crossing the line in my hypothetical of, he's not going to court, because you can't do that, although there were some guys years ago when I was in Orange County, these 2 guys were doing a bunch of criminal cases and misdemeanor stuff, DUIs and stuff for years. And they found out that neither one was licensed. For years, they were going into criminal court doing cases, but in my hypothetical, Florida is definitely licensed in another state. And he's here, and he's practicing law, not going to court, but doing those things that we do as lawyers. What discipline, if any, does California have, or is that gonna go back to the state in which he's licensed?
Prosecution. I would think you'd be responsible, practicing law without a license in California.
Right, that's the criminal, we're talking about criminal prosecution. The state bar can't touch it, right? Because they can only touch us if we have a license, right? Criminal action, very good.
Okay, thank you, Sheila. Hypothetical 4. Assume the facts of hypothetical 1, except when the court asked the respondent's attorney whether he was aware of the second job, the attorney admitted he was made aware of the second job and added income to the and he was aware of the second job, and he was aware that the respondent was getting the added income. But he failed to make the changes to the discovery responses as his mind was not clear at the time due to a death in the family. Since he forgot, it's fair to correct his client's testimony under those circumstances. He maintained was excusable neglect, not intentional. Instead of contempt, the court cited the offending lawyer for sanctions of $999 for failure to comply with pretrial discovery orders to make full disclosure of the respondent's plan. Does the fact that the court issued sanctions for $999 for discovery, okay, as it did in this case,
He admitted
and
he
not
was
a
aware.
citation for contempt?
I'm sorry.
Okay.
What was the last part of your question?
Can the judges, or are the judges, under those circumstances, required to report that lawyer to the state bar?
Yes, it's over $900 in sanctions.
No.
It's 1,000.
There are two things here. One, it's on discovery, it's a discovery sanction. And
Those
so
are excluded.
those are excluded, and two, it's under the $1,000 limit.
And that's
So-
excluded.
Mhm.
And sometimes judges will do that. I mean, I've seen judges in court in my years where the behavior may be egregious, but we all know the limit.
Exactly.
So if you want to make a statement, but not really get the lawyer in trouble, you go $999.
Right.
Now, with inflation, they should probably raise that. They did over the years in criminal law, raise the pay theft to, from $50 to $500 or something. But all I'm saying is that that's the threshold. And the judge's discretion says $999.
But even if the judge sanctioned him for more than $999 here,
It would not.
it would not, because it's still a discovery issue,
Correct.
as it's phrased here.
As it's phrased here. So, a judge is not obligated to report, there's nothing for him to report.
But remember that first hypothetical where the lawyer was asked about the income and he said nothing?
Right.
This hypothetical, he says, I knew about it. I was aware. I had a death in my family. I forgot to make the changes. That could be argued on the one hand as excusable neglect, but from the brand of law that I practice, I don't think so. I mean, I would clearly argue that you had an obligation. And this is suborning perjury. You knew. I mean, lawyers come into court, and I have a strong opinion about ethics and civility. They come into court and they come up with these excuses as to why, oh, Your Honor, I had a reputation in this county when I practiced law on a full-time basis, and Dale will tell you. If I said something to a judge, they could take that to the bank. I had no reputation at all for those kinds of things. Plus, here's the other part of it. I don't wait till the last minute to do anything. So when did this death occur? My mom died 5 years ago. I took 2 weeks off, didn't do any cases, didn't go to work, because my mind wasn't there. So you get that continuance for the hearing, and then you come back, you got your brain operated again. Oh, I forgot to make the changes. I mean, it's like the dog ate my homework. I just don't buy that, because these are important issues. You know that your client has income. You know they haven't put it in. And many times, it may be the client. Now, if the client didn't tell you, that's a totally different ballgame. But once I know, I have an obligation, and I think that burden should be high. Absolutely.
In this case, I mean, there's nothing to have prevented the attorney from coming in and saying, Your Honor, I have been mentally messed up because of a death in my family. I just now discovered that I left this. In other words, get ahead of it.
Right.
Don't wait till he's found out.
Right.
But as it's stated here, going back to Rule 8.3, it has to do with conduct involving dishonesty, fraud, deceit, reckless, or intentional. Is this reckless misrepresentation? Maybe so. That raises a substantial question: is that lawyer's honesty, trustworthiness, or fitness as a lawyer? So I think you have to look at the facts of the case and see, when did he come clean? When somebody said, by the way, what about this? And he says, oh my goodness, I forgot.
And the suborning of perjury is the other part of that, which is, I know, I allow my client to testify about it, right? And that's a crime. That's a reportable situation under 8.3A. It's a crime. It's a felony. As a matter of fact, I had to do some research recently on the case. I think I got it in my case. I'm excited. And I'm going to tell the guy before he answers my question, you have the right to remain silent. Don't answer my question, you're gonna get in trouble.
Keep in mind, the rule is a little bit different in criminal cases. Your client takes a stand and he says something
Yes.
which is false. The criminal lawyer has a different obligation.
Yeah.
He can further that perjury, but he can't report it.
Isn't that why you guys don't ask the defendant if he did it? John, would you answer that one too? Don't ask your client the criminal case if he did it, because if he tell you he did, you can't, your whole game plan is done.
And it goes back even further. When the lawyer is meeting with the client before he testifies,
Yes.
the client says, I'm gonna lie and say this. Well, then the lawyer says, that's perjury, you can't do that, that's a crime, makes things worse. I don't think you should I'm not gonna lie and testify unless you promise me you're not gonna do that. And the guy says, I have a constitutional right to testify, and I demand that right. What does a criminal lawyer do? Can't, you're in trial. You can't prejudice your client by saying, Judge, I gotta get out because my client's gonna lie. What do?
Do not argue it.
You don't argue it. And you don't follow up with any questions. You ask an open-ended question, he's gonna say what he's gonna say, and you can't correct him.
Yeah, but isn't that the danger of putting the client on the stand? I did some criminal defense work early in my career. When you know it, because we can't control our clients, right? I tell clients, don't say this, and they do it. Right? So you know, and now the client insists on taking the witness stand, right? And now that possibility exists. And then, as you just said, you can't get off the case, and you're stuck. And now you might be looking at something with the state bar. I don't know. Lawyer-client privilege? I don't know.
And that's why you go back to the same first hypothetical. When the lawyer doesn't say anything.
Right, right.
If it were a criminal case, for instance, the lawyer wouldn't be able to answer it.
Sure.
Okay? So, in this scenario, hypothetical 4, we know a judge has nothing to report, and we know that the offending lawyer has no obligation to report because he hasn't been cited for misconduct, and he hasn't been held in contempt. But under the reporting requirements of 8.3,
Right.
Sheila may have a different answer.
Right.
What is your answer?
And under 8.3, and remember that's the shall language, that's the 8.3 subsection A. And if there's evidence of a fraud or a crime, you shall report. But if you do report it, there's a comment under Rule 8.3 that says the following. Communications to the state bar related to lawyer misconduct are privileged, and no lawsuit predicated thereon may be instituted against any person. However, lawyers may be subject to criminal penalties for false and malicious reports or complaints filed with the state bar, or be subject to discipline or other penalties by offering false statements or false evidence to a tribunal. So that's your comment number 10 to 8.3. So,
You can't say me and my client assert the truth.
sorry?
You know your client.
So you have to be careful with that rule. Lawyers may be subject to criminal penalties, and it does tell us here, because we haven't discussed that yet, is that the reporting of the misconduct is privileged, and you can't be sued for it at all. But if you file a claim that's false or malicious, you can be charged. So we, of course, want to be conscious and aware of that possibility.
So in this scenario, Sheila, given the language of 8.3A, which you shall report, you feel that you are obligated under 8.3, given these facts, to file your report.
You know, we know that in law, there are two sides to every story. And I don't have enough information here to call it a 8.3 subsection A violation. It says excusable neglect, had a death in the family. There are all kinds of things that a bar is going to look at that might be mitigation. And if I'm going to turn me in, I want to be pretty clear. I don't want to be in a situation, because this is just a small fact pattern. You know how cases are. You'll have binders and folders of all kinds. Maybe there's records of health issues. I mean, all kinds of things. So I take the more conservative approach, and I would probably want to know more. So when I report it under 8.38, probably not.
Is this the place where you might report it to the tribunal
Could be.
instead of the state bar?
Yep.
Although the tribunal's already aware of it.
Right. So, but I wouldn't report it to the state bar. I think the facts are there, but it's not clear enough for me to say for sure there was a violation.
Sheila, would it matter to you that the judge hearing the case has already made a determination that it wasn't malicious?
Absolutely. Because the judge who makes that determination is going to make that determination based upon the evidence presented, right? And they'll can address that.
Would you want to make a record of the fact that inasmuch as the judge has heard this and has determined it was not malicious, it does not require a report under 8.3. Just make a record of it. That way, if anybody comes up and says you didn't report it,
Okay.
you've established in the transcript that there's no reason to.
Right, but as we all know, since January 1 of last year, we don't have any court reporters that bring it. Okay, so you got a little problem.
I'm so glad I'm not with that.
Cost me $750 for a half a day, just have somebody there to report what they all happened in court that day. Anyway, but I think that's a good idea, you put it on the record, you make it clear.
Yeah, so that was gonna be my question, is to what extent is 8.3 implicated when it happens in front of a judge and the judge is not required to report, right? Because it doesn't meet the $1,000 or it's a discovery exception. So now I'm a lawyer and I know the judge doesn't have to report, but 803 says shall, right? It seems like there should be some authority out there, case law or otherwise, that says, yeah, in those situations, 803 is not implicated.
But 803 is my obligation as a lawyer to report to you.
Correct.
Dale has a different obligation as a bench officer, as a judicial officer.
Right.
So I think that's where so I'm gonna have to take the hit, because if it's 803 subsection A and it's mandatory, then I'm the one who would be disciplined as a result of that. Dale wouldn't have that obligation. And I think that's fair, because under the circumstances, right?
So they should be viewed wholly independent of each other.
I agree. We got a may and we got a shall.
So let's ask a more difficult question. Let's suppose the facts are much more egregious, but the judge still rules the same way. You are the reporting or other lawyer who witnesses all this. Can you envision a circumstance where you would still report it even though a judge is found otherwise?
Given our recent conversation, I would say yes. If it's viewed as an independent obligation, I think I would want to go over my butt. Especially if it's a more egregious fact pattern. I think, yeah.
And added to that, Pete, because we're a small community here, most of us know everybody else. And so I might make a mistake. I mean, we're all people. If I see a pattern with that lawyer, right? Whether the situation is egregious or medium egregious, that pattern of me knowing that lawyer is probably going to be one of the factors I will consider as to whether or not I'll proceed. If it's a Pete Nolan and I've known Pete, I probably wouldn't do anything about it, because I know who you are. So I think that, there's more than one factor that we have to look at to make that determination before, because this is serious stuff.
Yeah, if it was you, Pete, I'd probably walk down the alley.
Could you satisfy that report obligation by reporting to the same judge that made that decision, as opposed to the state bar?
No, it's still the same one.
Well, actually, 8.3
Because
allows.
It requires that you report either to the state bar or a tribunal.
That's true.
So if you just report to the judge, he may not do anything, I mean, there's gonna be no consequence.
Yeah, I think clearly you make a record with that judge,
Yes.
that you disagree respectfully.
Right.
So,
And add the word respectfully.
Yes.
You know what it means, but just add it.
That's right.
Assuming you have no reporter, Judge, would you allow such a record to be made on the minutes?
I would.
Yes.
We have minute orders, which are still there, and as a judge.
I would have it in a minute order, yeah.
Would you please, I'd like to have the following added to the minute order. Good point.
yeah, respectfully, I once argued a case to a judge, a local judge, argued a motion, and he turned to me and, because he knew me, and said, Mr. Soto, I mean this in the most benign and kind way. But that was the most absurd argument I've ever heard.
Okay.
That was hell. Hypothetical number 5. Assume the facts of hypothetical 4, except the court found the respondent attorney's failure to disclose the income in discovery was evidence the petition was filed in bad faith and cited him for the violations under 128.5 CCP and ordered sanctions and attorney's fees to the petitioner. Anyone here think that under those circumstances, there is no reporting required?
Well, what did he do? He filed a false petition.
Correct. Let's hear from Dale to cover this.
I'll step up here. I've got a few pages here on this one. And the reason I have a few pages is because I thought, we attorneys live to parse words, don't we?
Yep.
Well, let's see, 128.5 says this, trial court may order a party, the party's attorney, or both to pay the reasonable expenses, including attorney's fees incurred by another party as a result of actions or tactics made in bad faith that are frivolous or solely intended to cause unnecessary delay. I haven't seen the word sanctions there. So, as an attorney, I'm parsing words. Well, that's not a sanction. It's attorney's fees. But are attorney's fees awards under CCP 128.5 reportable sanctions? The answer is yes, they are. Because if you look through that entire statute, you'll find out that the words are used interchangeably. Sanctions references attorney's fees. For example, let's see, 128.5 F2 describes the available remedies. An order for sanctions pursuant to this section shall be limited to what is sufficient to deter repetition of the action or tactic or comparable action or tactic by others similarly situated. Subject to limitations of subparagraphs A and B, the sanction may consist of or include directives of a non-monetary nature, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of some or all of the reasonable attorney's fees and or other expenses. So when you look at their sanctions, is a broad description that covers a lot of things, including the attorney's fees that are subject to 128.5. So the statute explicitly characterizes attorney's fees as sanctions. And so it covers everything that falls above the reportable threshold. So is it above the $1,000? For example, if the attorney's fee award is $999 under CCP 128.5, judge is not required to report it. But if it's $1,000, it is reportable. If it is $5,000 under CCP 128.5, it is reportable. And if it's an attorney's fees award of $5,000 under CCP 128.5, it's reportable. If it's a fine of $2,000 paid to the court under CCP 128.5, it is reportable. So any of those sanctions is reportable if it exceeds the level there. So whenever a court issues an order imposing under CCP 128.5, it exceeds $1,000, it does qualify. And notice this, Business Professions Code 6068010, this subdivision is only intended to provide that the failure to report as required herein may serve as a basis for discipline. So failing to report, self-report of the attorney is possibility of discipline. Incidentally, I looked up a case last night. The case was Attorney Gregory Paul Ricks of Tustin. Don't know if anybody knows him or not. But in 2024, he was cited for failing to report judicial sanctions, and it was finally entered as a final order in December of last year. It's 1 year probation that begins with a 30-day suspension. He's in the middle of that suspension right now. So I double checked to make sure that that's correct. So what about the fact that this could be a discovery sanction? Is that an exception? No, it's not an exception, because it's a sanction for bad faith conduct. It's not a discovery sanction. It may be a sanction for bad faith conduct with respect to discovery, but the reason it's being sanctioned under 128.5 instead of under 2023.030 makes all the difference in the world. CCP 2023.030 and all those other 2020 some whatever numbers, all of those have to do with discovery issues. So if the sanction's under 128.5 of the CCP and it meets the threshold, it is reportable. If it's reported under the discovery status statutes, it's not. Also, if sanctions are imposed against the law firm, each partner or shareholder must report regardless of whether the firm has already done so.
So you're saying that there are 3 partners in the firm and 1 partner is subject to a sanction, all 3 must report that?
Unless the firm has already done so. As soon as I said that, I thought that was wrong. Yeah, if the firm has reported it, then the individual attorneys do not have.
Do not.
Yeah.
Got it.
So,
There's a hand back.
Yeah, of course. I have a question. You know, maybe I'm hallucinating too much about this. But 128.5 to me, it assumes that this lawyer's conduct, besides telling the story about the death of his family, there had to be other conduct throughout, maybe motions to compel, maybe he was totally obstreperous during the entire discovery period. So the judge awarded these damages, these legal fees on 128.5.
right.
Let's say the lawyer said, no, I really did have somebody die in my family. I'm operating here in good faith, and that's the only reason. If he then decides to take the judge's ruling and seek review, because he doesn't want it to be reported, then what?
Too late, the judge has to report it, and has to report it immediately. And the state bar is going to review it. So, I mean, the fact that it's reported doesn't mean that you're going to get dinged. It just means the state bar has to look at it, has to investigate it.
It's a permanent record.
Yeah, it's on your permanent record, right, okay. Which would have been helpful with Girardi, if there had been a permanent record.
No kidding.
Anyway, so, give you some ideas. What if, for example, an attorney is hit with multiple sanctions in the same case? Each separate order has to be evaluated independently, and so you have to look at it this way. Let's suppose that the court imposed order number 1 of $800 in sanctions, not reportable, under CCP 128.5 because it's under the $1,000 threshold. Same thing with the second order, $700 in sanctions. But then he makes a third order of $1,200 in sanctions. That one's reportable. So even though the court has imposed $2,700 in sanctions, only $1,200 is reportable. The court does have the attorney, the obligation to report. The attorney has the obligation to self-report. And so what happens if you get hit with 128.5 sanctions? First thing you do is you calendar 30 days for a deadline to respond, to make your report. You gather the required documentation, you do the self-report, and just, if there's a question of whether you should report, if you're in doubt, report. Do the self-report. You don't want to get yourself dinged for failing to report when you should have. It'd be a whole lot better if the state bar comes back and says, you know, you really didn't have to report this and bother us with it. I mean, then you look pretty good. If you go You know, if they say, you should have reported it, you didn't, you don't look very good.
Thank you, Dale.
We're actually done.
We're going very well. Do we need a break now, or we're good?
Well, I think we do have those hypothetical six of them.
Okay. Hypothetical 6 is the one I had been looking forward to, and I hope that we have a lively discussion on this one. Hypothetical 6. Assume the same respondent is filed for reduction of spousal support. The claim is the same. He is only employed by witness A. At no time does he disclose he has a second job working for witness X. His lawyer mistakenly sends opposing counsel the following email thread. Respondent: these interrogatories are asking me if I work for anyone other than witness A. What should I put for the answer? Remember, I told you I was working for, and still do work for, witness X, who pays me under the table. Like we discussed before, we don't want my ex to find out about that, right? Should I just not mention it? Attorney for respondent: what do you mean? If you disclose you work for witness X, you'll lose your request for lower spousal support. Come on, do you want lower payments or not? If you tell them that, our case goes down the toilet. You cannot disclose it, period.
Turn in his license.
That,
I'm so proud.
This was, yeah, really.
and lawyers have done stupid things like that before. As the opposing lawyer and recipient of this email, he clearly knew it was not intended for him. What should he do?
Don't read it.
What would you do?
You don't read it and you inform opposing counsel.
Hmm?
You don't read it once you realize it wasn't meant for you, and you inform the other side.
Right, and it might take you a line or two or three before you realize it's not intended for you, and
I was
that's when it's
given
not.
the situation as he knew. So that would be my answer. Now, if I were to read this as I was studying this, I'm told this is not meant for me. But it depends on how I'm reading the email and whether or not I can restrain myself from reading any further.
Correct.
So do we tell on ourselves that we read even further because I have been placed in that situation?
We all have.
Yeah.
No lie. So that raises another, that situation where it's like, I read it. What do you do? Now, in my case, I reported it. This is my personal experience. It was before this rule, I believe. It was years ago, let's just say.
Who did you report it to?
I'm sorry?
Who did you report it to?
The attorney that it was meant for. I was copied.
I got it, okay.
Yeah.
Okay.
So you reported to the other attorney
Yeah,
that
gotta call the other
that you
attorney.
read it.
Right.
Say we got a problem here.
I said, look, this was sent to me inadvertently. I read it. It was not meant for me. You should be aware about it. And it turned out that it was not a big deal for them. But I wasn't certain about it because it seemed to, be substantial to me.
Yeah, but how do you forget, assuming you read the whole thing and you didn't realize it, how do you get through that in hearing? I've got this client who wants a decrease. He's already telling me, I'm not gonna say anything about this income. The lawyer's going, you do that, you can just forget it. You're gonna lose. So how do I, as the person who got that email, right, respond as this hearing goes on and continues? We'll see other hypotheticals where you can't threaten people or tell, I tell you what, if you'll do this, I'll do that. Those are things you can't do. But that's a real ethical dilemma that we have, because we know.
Then we must report.
What would you do? Yeah.
I know the rule says that you have to not read the email and let the other party know, but like Sheila mentioned, I already know this is happening. I've already know that someone's gonna perjure themselves or not turn over all the discovery. I feel like somebody has to know about it. I've never been in that situation, but I feel like somehow there's gotta be a way to get around.
Gonna settle this case.
There you go.
Yeah.
There you go. You gotta know when to hold him, know when to fold him, know when to walk away, know when to run. Time to settle, guys. Right?
It's their turn to settle the case.
Wrote privilege across mine,
Huh?
privilege. But then somehow
It's been
it got
broken
out
because
to the other lawyer. But
So I was in a case in Orange County years ago, and the judge at the time was ultimately elevated to the federal court. John probably knows it. But guy comes in a small claims court and commits perjury. Okay? And what did the judge do? He called the DA's office. They got a prosecutor up to his short court in 5 minutes. The guy got hooked up in court. Right there. So all I'm saying is that when you're armed with that information, if it didn't settle, see, that's where the dilemma comes in. You know, if that were me, I'd tell Michael, we need to settle this. But sometimes, like Rod brought up the hypothetical, it's like tells him he did it, but he insists on taking the witness stand, and you gotta keep your mouth shut. I mean, what do you do? It's a tough dilemma to be.
I guess I wonder, and I was talking with Rod about this earlier, I wonder, what is the impetus for the attorney who sent the email to settle? Because if you weren't supposed to have read it,
Yep.
then you can't use anything against me.
Right.
You got nothing, why should I settle with you?
Right. 4.4, that's the next slide.
Yeah, can't you use it in a people?
But we're not gonna go there yet.
Sheila, who's the judge that called the email, or called the GA?
He went to federal court, I don't know if he's still on the bench,
Gray?
no, it'll come to me.
Dave Carter? No,
Carter. Carter,
that sounds like Dave Carter.
Dave Carter. Is he still on the bench? Is he still on the bench?
Yes, he is in the federal court. I just saw him not so long ago.
Okay, tell him his name.
Tough guy.
So what would you
He's a
do?
really reason.
In that case,
Well, you know, you that's an interesting issue. So all these ethics rules are geared towards keeping lawyers honest and from committing crimes. And here you have a lawyer who's supporting perjury for his client, even though the email went out by accident. So, you know, do you have an ethical responsibility to report as a crime? This is a crime, supporting perjury, or to use it as leverage to settle, that we already talked about. You know, I'm hard pressed to commit to reporting it to the court, that here you have an officer of the court supporting perjury, but, you know, ideal, under the intentions of the rules, then maybe you have that obligation to advise the court.
couldn't you use it, you're obviously the attorney that sent it to you in error is gonna know that they sent it to you in error. And you could respond and say, I've received this email in error, and I did read it before I realized it wasn't to me. Period. And if that person then testifies contrary to that, can't you use that as impeachment when the person is testifying and he says he didn't have any other earnings?
Yeah, but now you're the lawyer in the case, now you're gonna leave your counsel table and go to the witness stand. I've seen that happen, but you're right.
You can use it as to impeach basically the credibility. Then you'll be up to the judge to determine.
You could use it for extortion too, and tell them, give me $5,000 and I won't report this.
You settle.
All right, here's,
But again, I mean, I find that question interesting too, but the thing is you weren't supposed to have read it.
Right.
So if you read it and you weren't allowed to, then is that anything you learned from it after the point at which you realized it wasn't for you? Isn't everything you learned fruit of the poisonous tree and you can't use it?
But how far?
Whether it be for impeachment,
Doesn't it depend how the email's addressed? If it says, "Dear Fred," and you're not Fred, and you start to read it,
Right.
what if there's no caption and it just starts in on the basic content of the email? You may not know till you get to the end and say, "My God, this wasn't meant for me."
That's right.
but let's suppose, all right, so let's suppose it isn't till you get to the end. Now you've got a situation where you know they are talking about committing a crime.
Right.
Rule 4.4, duties concerning inadvertently transmitted writings. Where it is reasonably apparent to a lawyer who receives a writing relating to a lawyer's representation of a client that the writing was inadvertently sent or produced, and the lawyer knows or reasonably should know that the writing is privileged or subject to the work product doctrine, the lawyer shall, A, refrain from examining the writing any more than is necessary to determine that it is privileged or subject to the work product doctrine, and B, promptly notify the sender.
You can still do both of those things, but still gather the necessary information that's damaging to that party's case who sent it inadvertently.
And if you do both do those things, you can maybe use it for impeachment, I would say.
That's what I would think too.
And this section cites to a case called RICO, it's in your materials.
We're gonna get to that.
Okay.
How many of you take that view that you could still use it to impeach?
I still think it's privileged.
I'm not sure you could use that letter, but perhaps you can use the information contained to investigate. Maybe I contact worker X and say, hey, does this guy ever work for you? You know, and worker X says, yeah, he still works for me. He's been working for me. And then, lo and behold, at the trial, worker X shows up to testify.
So you've used the information that you should not have looked at.
I'm talking that through, and I don't think you should bring that either.
The problem is, if you violate this rule under 8.4, you've committed an act of misconduct.
Right.
That's the problem.
Wait, can you say that again?
If you violate this rule under 8.4, rules of professional responsibility, you've committed an act of misconduct because you have violated a rule.
You'd have to be pretty brazen if you're the lawyer that wrote this response and you're the one that inadvertently sent it to opposing counsel, and you're now told by opposing counsel, hey, I've seen it, here, I'm sending it back to you, and you still put the guy on the stand to say this? I mean, pretty brazen on that lawyer's part.
Okay.
The lawyer that sent it inadvertently, he committed malpractice, he was negligent. You don't send things inadvertently that's pertaining to a client, you make sure who you're sending it to.
Your staff sent it.
Well,
Things happen.
you're responsible for your staff.
That's true, but things happen. Yeah. I mean, that's what negligence is by definition, right? It's not
It
something
is.
you intentionally did, right?
You suggest that lawyer tell his client to find a new lawyer to sue him.
That's something that should be considered.
The
Definitely
the
describe.
hypotheticals get better for our discussion. So why don't we take a break?
So what do we do in this case?
Huh?
What
Come back and find out.
You're gonna find out.
All the disputes.
Don't do family calls.
Good point. We'll reconvene at 2:45, take a break, walk around, and we'll come back and wrap for you up here. Thank you.
That's how we get you to come back.
That was perfect, Wendy, that was perfect.
Cliffhanger.
That's exactly right, it's the cliffhanger.
Huh? Oh, they did.
It was a team effort.
We're in the criminal practice, you don't have to worry about it.
They enjoyed working together, it was a good experience.
Some good stuff here.
Oh, yeah, well, that's good stuff.
You know what you got? That's right.
Hey, thank you for being on.
But we've got to tie her together.
That's right.
Yeah.
At the end.
Thank you for keeping us in check, because I'm like, you know, we ain't talking about that now.
That's right, exactly. I was ready. In fact, I leaned over to her and said, wait, come on, we're going.
Oh, yeah. We're ready. Great job.
Oh, you did a great job.
Anything, John?
No, but I want to know, are you reading these days?
Am I reading?
Yeah. I have this handout
Reading
for
for
tomorrow
fun?
that I did with this friend of mine years ago.
Oh,
I want to give you a copy because
Okay.
I've probably seen everything else. Claudia, it looks like you're interested, that's good.
It's,
Are you having fun?
I thought it was gonna be boring.
Well, it is.
No, it's interesting.
Don't say it is, John. Hey, hey now. Mhm. No. When they could keep their mouth shut when they mentioned about the rich.
I know, I was gonna say something. I still may. Nothing that says you can't do it.
I think this would be worth some money if somebody screwed up like that.
Hmm?
I think that'd be worth some money if somebody screwed up like that.
Mm-hmm.
Yeah. This is
Never-
one of my
You never
handouts.
need to give us two, because you know we're
I
one.
know.
Um,
One of the handouts for the one, which is such a good name.
Selling more business.
I'm gonna come tomorrow because I do my.
Good, good, good.
Sure.
We have a handout too from our heads of court the other night on civility, which I should probably read those out a few times. And this is it's not about making money, it's just about developing trust and compliance and referral sources. This Ed Robinson, I messed around for a while, I don't know if it was published for 3 or
Just
4
because money.
You're sure?
Yes, because
Wendy,
I bought a book on Amazon on how to reduce clutter.
oh, clutter, I see.
And one of the things they say is do not have multiple things. But the weird thing is Amazon sent me 2 copies of the book.
Of course. Watch out for clutter.
Which I thought, that's a little weird. I was bummed that we were working on the program this morning, so I missed, was it Greg this morning?
Yeah, Greg Dorsey, he's great.
I wanted to see
He gave us the
him.
full story this time.
I wanted to see him so badly, but we were still working on this.
We've got the video.
Oh, you do?
Oh, yeah, they're recording it.
Oh, okay. I will ask you
Yeah,
at some
he's,
point how I can access.
He's the only guy I know that's been busted in court and
Yes.
taken downstairs in the lockup when he was not practicing.
His story is amazing. I've heard about it.
That's quite a story.
He was hanging around with a couple of bikers over there in Fontana, you know. They threw a little meth on his table instead of money.
Yeah.
I had some.
Well, I thought it was it just meth or was it, I thought it was guns too. I thought I heard.
The DEA had a few people out there at one time in the 80s, you know,
Yeah.
trying to mess people around.
Wow.
I gotta call my buddy Kenny Fisher. Fisher was F. Lee Bailey's partner the last 10 years of his life. And he, I guess, I don't know if Massachusetts has some rules, but Bailey hit about a point and a quarter of doers, you know, and then once I went up with him on his boat to Maine to get lobster.
Oh, yeah?
It was very nice, and then we're coming back, and he has this big quart bottle of doers, and he goes, you pilot the boat. What are you talking about? He said, just keep the lights to the right. I went down, and I had to go to the Boston Harbor. I was making my way through.
He made you go into the harbor?
Oh, yeah.
Oh, dear.
And there's 2 guys in a small boat with a shotgun across their bow.
Uh-oh.
He says, I'll go ask them. And I said, when I asked them, I said, go to the boat now. So I found my way back to Squawkin Harbor.
Uh-huh.
Right.
He took on his wife.
That was most
That's
of
it for me.
it's hard to
Can't
get
keep
used
on
to.
one
Yeah.
time.
More.
Yeah. Brand new character. Actually, it's fun to watch.
Photographic memory.
He's really
Smart
smart.
as guy.
Okay, so on a personal level.
Yeah.
When he hits town,
So what did it feel
2
like?
trials and he never does.
He's analytical, he's thoughtful,
Oh, he is.
and he really
Tell me
that's what
tell me what it feels like. Use the chart.
I remember this girl from, yeah, that's you. 1983.
Did that really come to your mind when we were watching the building?
I was in there and I was in business. They gave me value.
Make sure you find out a sweet. I mean, a bunch of cookies, I stayed away from the cookies. Oh, no. I had two of them. I had two sandwiches.
Yeah, I remember.
And I loved the olives. Then I remember that texture.
It's been 15 years.
I'm hurting myself twice. I looked at it, but I can see
Skateboard. Really disappointing. Very lukewarm, milk toast response. And they were big serious issues as well.
you know, that, you see, they don't have their insurance or after some years, he said it to me. I don't know.
This, I think,
It looked like it was a
it's
dress.
very political. An attorney is running for political office, city council. His opponent is also an attorney running opposing. Very acrimonious campaign. Attorney A started posting his social media, his social security number, home phone number, address, despite repeated pleas to not do this, it's violating all kinds of. Yeah, and the bar didn't. And I got the real strong sense that they were afraid to interfere. I mean, it was political horsepower. And then, so that you mentioned Aaron Brockovich, well, her boss, Mazri, did some very high-end things. He appealed, he used Fear Factor and had websites. You suffer from cancer, Hodgkin's, any disease you can think of. Join my class action says, we've got conclusive proof that says this. But I testified against him. He had law intern kids that weren't properly trained, going out and collecting methane gas stations. And what he wasn't telling any of his clients is the background chemicals. The reported amounts of methane dioxide were well below the background for city of Beverly Hills. There are absolutely nothing there. But it was so obtuse the way he presented it. He got all these plaintiffs fired up.
I didn't watch the movie.
Well, there's a really good book called The Lead Scam where they write about all the manipulation. I'm not defending, the oil companies for what they did, but I'm just saying it was very, very skewed.
Yes. I was in the liquor to the policy, never been over.
She knows what I expect.
And the entry also.
But we just appear the record began to inquire, that would be the good, bad, and the ugly. And you can use anything.
Yeah. She stays over and my other sister came out as well, so we're both like, yeah.
You know, there's no way that first day is.
I don't get out here often. I tell them, for sure, once every 2 years, I'll show it. So.
That's a good plan.
I will find my link to Fred Schmidt and some of his music. I'll send it to you. I love his production quality. Like the sound is mixed perfectly. I mean, and I'm pretty old listener, but I love the way he does it. Yeah, beautiful voice.
Well, I have said
You know, I have a fossil, I have a dental stereo, which I love something. But, the pods start to build up oxidation. So you got electronic cleaner, you got to clean them all up. I mentor now robotics
4 different high schools on a regular basis. This next Saturday in Monrovia is supposed to be 30 teams competing, and I'm at school, so I actually get excited. Well, there's first robotics, and there's first tech challenge. I'm first tech challenge. These robots are all robots, but they're only worth 2,000 to 3,000. First robotics, predominantly are very expensive. Their robots are 20 to 30,000. Huge. The stuff I work in is in the realm of schoolhouses, so.
It's not there.
Oh, yeah. No, they're basically little mechanical constructs, and they're supposed to do simple things, like go identify, pick up the yellow balls and put them in this basket. You get points for autonomous programming, and then you have joystick operated you try to help, I used to think programming skills, but high school it's more just soft skills. Kids were teamwork, delegation, after hours, school hours, when you was pushing up the out, they said it's good. I mean, there's a lot of things that you'll see this again in real life. So.
George here, he's a guy that robotics, so bad.
Oh, wow. Yeah, you know, down well that Suzanne.
No, I'm mentoring kids at 4 different high schools.
Oh, okay.
This Saturday is what we call First Tech Meet, regional, 30 schools competing on head scorekeepers. And this is one of the final events.
Yeah, I remember we got, just back when I was with the VA office, I was on our union board, and we, I remember we had a couple kids on the robotics team, who were also on the mock trial team.
Okay.
And we donated.
Yes, I know,
money to
And
robotics.
what's I explained program, most public schools will be, if they have a robotics team, it'll be First Tech Challenge. The counterpart to that is First Robotics Challenge, which is a lot of private schools. The cost difference is $2,000 for a robot, $20,000. The First Robotics is much more expensive. They have major corporate sponsorship. And we're talking F1 teams, I mean, big right. And I'm happy for them, but my place is with public schools, because I'm helping a lot of kids get something they'll never see. So I like to mentor them, I'll give them an English, and I never give them the answer. I say, what do you think structurally? What's the best shape can we work? Is it going to be a tube, a hollow cylinder, a square beam? What's an I-beam do for you? And then I'll start talking about modes and inertia and things, but the kids start, a lot of them are pretty smart. They just,
they'll get it.
but the thing I see over and over and over again, day one, a boy, there's so many things, and I can tell his father's a mechanic. He's been around tools. He knows. They'll be typically an Asian female who's terrified to speak. ESL student, but her eyes, I can see she's doing tricks.
Right.
Put the two together.
Oh, that's
It's amazing what can happen. Yeah. The other thing I do every year is, I think I told you, the Baker to Vegas law enforcement.
Oh, the run, yeah.
I'm working for Cal OES on the medical support net. So in advance, I set up 2 repeaters on Turquoise Mountain, Ibex Mountain, and then on top of the hotel in Las Vegas. So I said, and we equipped 24 ambulances with special radios. And we run the event as a linear city. That way we keep Toronto and Shaker and the sheriffs out of it, because they don't want it. And some years we get a lot of medical calls. But I discovered there's a lot of, in addition to law enforcement, we got prosecutors, DAs, investigative teams. It's a wheel.
I remember our Baker Vegas team was very competitive.
I'd hear about that.
Like you have to, if you didn't run so fast, they had to try it. You
By the way,
couldn't
did
be on the
everybody
team.
sign up on our list here
Yes.
for your MCL if you did not?
They call it the testosterone run, and a lot of them increase that.
Yeah.
That's why we have hot weather. Get our.
Anybody else? Everybody done?
Is there some issue?
Again, it keeps me young.
He just comes up with stuff.
That's neat.
Yeah.
I remember I was telling him, we were sharing our,
Every year I support this.
as you know, I remember me and Andy, he wasn't a judge, he was the,
Yeah.
I remember, he was a graduate. And so.
It's a big deal for certain departments. I know in the past, I've seen
Gables College.
all reimbursed. We used to get involved.
I've been coming back at 54. DHS. All right. He was a doctor. He was the only doctor. He was treating arthritis. So he came to their hot springs. And he had a medication for arthritis. So he came here and
And
we lived here about a year, 1954. DHS was
And then I always
time.
needed squad cars.
My brother he worked at the
Two people, hot spring.
so we had a nice little
Get all
town.
time.
So now you can have over here.
Yeah, that was.
Then we came back from that, shit, sugar.
I'm gonna bring her in.
3 minutes. And so some of the earlier yes,
It starts at 8 a.m. and it ends 2 or 3.
Yeah, when he left the DA's office, before he started, we had a standing every week. Sharing, the lunch just stopped.
yeah. No, he had his name in there. Well, I did a trial with him. Oh, yeah.
Cameron, how you love the ride?
Just so, he was so proud.
That's.
Yeah, I did 2 trials. Yeah. And I knew I could count on him, trust him. That's what I was.
He wasn't gonna put any full names.
No, that's right.
Sticking to our being on schedule and on time, if I were on the bench, we would start at 8:15 when they turn we are. It is now 2:44, we're getting ready.
1 minute.
We're gonna start part 2 and finish up the rest of the materials, but I just want you guys to know that it's been very stimulating for me so far. You guys are all fantastic, have some great thoughts and ideas, and that's why we do these presentations, because it really is about
Thank you.
us all doing something out of it, right? Okay, we shall continue.
Donald Sternberg wanted to say hello, come on in.
A lot of these guys have been on our program for years and have met AJ when she was just a young kid.
I'm taller now.
So this is great. Oh, this is Dawn.
Let's keep him around.
Just did a closing argument in double murder on last Thursday. Excellent work.
I heard it was stellar.
Thank you.
Wendy said so too.
I did
It
too.
was, I was there, it was honestly fantastic,
Thank you.
fantastic,
And also trying to get under the
Very-
table when the earthquake hit.
I did. I was under the table before it stopped.
What are you doing there?
Yeah, he didn't feel it.
No sensitivity.
But John gave me the advice that is the important advice before the closing argument, which is don't fuck it up. Hopefully, the legal term, right?
Legal term. This is not a good time.
Thank you. Good to see you.
Good to see you all.
But you did good. Way to go. There's another 12 years. So we're in the 277 years. 677.
John, you're too young to have a daughter that old.
I know.
Come on.
Can you believe it? She's gonna be 43 in August.
Wow.
August 19th, 1983. She entered this world, I was there.
Hope so.
Well, I read reserve.
John wants to take off the credit.
All right, the next hypothetical, let's see how the attorneys handle this situation. Assume the same fact as hypothetical 6 above. Assuming further the petitioner's attorney reviewed Rule 4.4, and upon receipt of the inadvertent transmission, elected to contact the lawyer. During the discussion, he told respondent's attorney that unless he dismissed his petition for reduction in spousal support, he'd take the email to the Riverside County District Attorney's Office and push for a criminal prosecution for suborning perjury. The respondent's attorney agreed only on the condition that the petitioner and petitioner's attorney agree not to report this to any law enforcement agency or the state bar. Petitioner's attorney and petitioner agreed. The motion for spousal support reduction was taken off calendar.
So what are you doing now after having both been
So, what is your opinion about the way the petitioner's lawyer handled this?
Bad.
You know, since I was a very young lawyer, there was this cliche that you could not threaten criminal prosecution to gain a civil advantage. And that's what you got here. I think that still holds true.
It does.
Yeah.
An interesting corollary, and we'll get into that. There's an interesting corollary to that rule though, an exception, and we'll get to it. Anyone else think differently?
Which one, the petitioner or the other one?
Both of them.
Yeah, both of them have problems, yeah.
Okay, so the threat to prosecute is one thing. All right, what about the other's negotiation tactic, which is, we'll do that if you don't report this to the state bar or law enforcement.
That's not good either.
Why?
Subrogation.
Not ethical, obviously, and,
All right, let's take a look.
Forget altruism for a minute, it was a wise counteroffer.
It wasn't what it was.
The case went on calendar, right?
Rule.
There was no money involved.
Rule point 310, threatening criminal, administrative, or disciplinary charges. A lawyer shall not threaten to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute.
Go down that area, go.
So that's correct. If you go down to the comments, what the state bar does tell you is, you can tell the other side, I'm going to report you to law enforcement over this. But you can't add the unless.
okay.
No quid pro quo.
No quid pro quo.
Or you do it. Or you
Or
just do it.
Yeah. Or if you do it. But that creates other problems for you if you do it, maybe. Think about that.
So let me-
8.3, Rule 8.3, comment number 10. Communications to the state bar relating lawyers' misconduct are privileged. Lawyers may be subject to criminal penalties for false and malicious reports or complaints filed with the state bar, or be subject to discipline or other penalties by offering false statements or false evidence to a tribunal. Do we have that in this situation? There's an agreement not to report something that you're obligated to report. Put you in violation of Rule 8.3 as well. For several reasons, think about it.
So remember, 8.3 subsection A is the shall portion, right? And to refresh your memory, a lawyer shall, without undue delay, report to the bar or tribunal with jurisdiction to investigate or act upon such misconduct when the lawyer knows of credible evidence that another lawyer has committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, reckless or intentional misrepresentation or misappropriation. That's the shall portion of it. You have an obligation to report under those facts.
But the attorney who has the obligation to report also violated the state bar rules.
Exactly.
Now what?
Cross-reporting.
That's right. Dueling reports.
You gotta report yourself too.
Right.
See what happens when you're overzealous, which is the reason why the state bar took out the word zealously represent your client.
It's not in the rules. So do we know what the penalties are? I'm just posing this next question because we know, under what circumstances we have an obligation and a duty to report. What's gonna happen to me? This hypothetical, for example. We know it was a magazine years ago, in my early years of practicing law, and every month in this particular magazine was the list of lawyers who got disciplined. They don't do that anymore. And in every edition, there was the lawyer of the month, who did the worst thing in that whole month. And so, but there were things like private reprovals, where they send you a letter, don't do it again. Public reprovals, we put your name in some publication. We have, you can be disbarred. I mean, there are different levels of discipline. And I don't know how that plays into any of the various scenarios we talked about, but those are the possibilities of what the state bar could do in terms of the kinds of things that we have talked about with these ethics violations. They could take a bar ticket, put you on probation.
Rod, you just said something that stunned me. And I never even thought of it until you just said that. That's why the state bar took the word zealous
Yes.
out of the language.
Yeah. Remember the old state bar rules used to say you will zealously represent.
We geezers here were raised on the idea of zealously representing our clients. Never thought about the dark side of that like we're talking now.
Right.
It's really shocking. I mean, it's really shocking how the word zealous has been perverted because of actions by lawyers who decide they're not going to act by the rules.
Yeah.
I think there's a lot of lawyers that act like anything you can get away with is okay.
Anything you can get away with.
That's my job as your lawyer.
Right.
Commit crimes and perjury and put on false testimony and hide the ball and whatever it takes, right?
That's the nature of change in society, I think.
Wow.
Because we've been talking about all morning, we were talking about human nature from an ethical standpoint, from a bias standpoint, and how the law has bent to take into dark side of human nature into consideration when dealing with our own. And there's something really troubling about that.
Cutting corners.
But I think that we see, and I certainly have in my 45 years in this business, seen situations that have escalated to the point of being out of control and understanding why rules like this in 2023 came in play and why civility is now required by the bar. But back in the old days when I practiced law, you called up your colleague, right? You had a conversation about your case. We weren't concerned about documenting everything we say, right? You put a deal together, done. I remember back in the old days, judges, I was in Orange County at the time. You walk in on a trial day and the judge would say, so what do you all got? Oh, okay, well, come on in the chambers. You sit in chambers and we work it out.
The good old days.
The good old days, right? The good old days are over. We want to document everything we do. I'm one of those, and maybe not everybody practices well the way I do, but I copy off every email and every case that I have. I have boxes and boxes and boxes. Because why? I mean, yes, they get stored on the computer, but your computer crashes, there's all kinds of stuff. And I have to document everything I say. I had staff years ago, and they got pissed off at me because I go, now, did you document that?
Right.
Well, no, well, go ahead and do it. Send an email to the client and tell them, because it may not come up every day, but the one time that it does come up, you don't have something to document your position. So that's what we are in today in the practice of law. We are covering our butts. And it makes it very uncomfortable. And so there's a lot of, it's like, because I do divorce work, spouses don't trust each other. Now, lawyers don't trust each other. I may have a conversation with you, but you're gonna turn around and stab me in the back if it works for your client. So we're all in a totally different game plan. I tell my colleagues, and I'm thrilled that I'm at the end of my career, right? I can abort any day now. I haven't, but I can.
Sheila, you don't let them get away with it either.
Exactly. But it's a whole different climate out there in how we practice law. That makes us, and I was telling Pete earlier and a few others, every time I would do these seminars over the 45 years of my career, I'd go home and I'd be nervous for a whole week or two. Like, did I do something wrong? Did I forget to do this? I mean, you think about all the stuff we're learning and all these rules that apply to us. It's pretty scary. But here's what I've learned. If you always do the right thing, you got nothing to worry about. You got nothing to worry about. I'm not gonna lie to you. I'm not gonna tell a client that here's what you're gonna get when I tell my clients, you know what? Two things. Number one, I'm like a hooker, I get paid by the hour. And number two, if I had a crystal ball, I'd pick the 6 lottery tickets, win the $5 billion and leave America. Other than that, I got no control. I'm just going through it every day. So, but if you do the right thing, you know, if you don't hide the ball, if you're cordial with your opponents, you can't control how they respond to you, but you keep your side of the road clear. And I can guarantee you, you will have very little to worry about, because I am prepared to defend everything I've ever done as a lawyer for 45 years. Take me now.
One thing I'd suggest is remember that the first word of this is rules of professional responsibility. One of the things I noticed as a judge is that way too many lawyers become their clients. They stop being professional and they take on the persona of their client, particularly in family law. And if you're just going to be like your client would be without you, then that client doesn't need to be paying you money. They don't need you. You need somebody who's going to be able to control your client. You need somebody who's going to be able to talk sense to your client. Someone who's going to be able to be professional with the other side. Someone who's going to be able to behave responsibly before the court. Way too few attorneys behave professionally anymore.
But I was family law lawyers get people coming in and saying, I want a mean son of a bitch to be my lawyer.
Right. The clients usually pick the kind of a person that they are. If they want vengeance because you've done them wrong, they're gonna find somebody to do that. I was at a 10-hour family law mediation Monday night. Through the earthquake. I forgot the rules, but I get on the desk when it passed, so I was okay. After 10 hours, here's the conclusion that I reached at the end of the first hour. I knew who the problem person was. I knew who the problem lawyer was. And we worked 10 hours. And we were so close that it wasn't worth continuing a fight that's going to be in trial in 2 months. It's going to cost each side at least $50,000. And one of the lawyers, after the mediation, before it ended, I said to the one client and lawyer, I'm done. Obviously, y'all just want to fight. And I'm done. So the next day, I contacted both lawyers, sent an email, and I said, you know what? I am prepared to donate 1 hour of my time by a Zoom call for both lawyers, no clients, to get this case settled. One responded, the other did not. To this day, you walk away. You walk away. So clients want you to take on their persona. They want you to take on their anger. They want you to take on their why I want to get retribution against you. And I just don't allow that in my practice. If that's what you want, go to somebody else. I don't do it.
Can I see, what about, I don't do family law, thank God, I've never done it. But it seems to me, having people who have gone through divorces or child custody cases, that it's the motivation of the lawyers, it's all about money. What about if they hadn't placed a limit on what attorneys can charge in a divorce?
Well, I don't think that helps. I think it's just the nature of the person who's doing that work, okay?
But they are gonna get rich, if they can keep.
I mean, they always do. I told
They
you
do,
when I
you're
looked.
right, the clients
I mean,
do all
you
that.
know, 10 hours at $500 now, that's $5,000.
That's a lot of money.
That gets me to France for a month, right? So I wanna go 2 months, so I need to do like double the amount of work. And by the way, there's always a conflict in my view, especially in family law. Here's the conflict. If I settle your case too quickly, I'll make a lot of money.
You're right, right.
And there are people who operate that way. Or they wait until that fee gets to be excessive, right? And now they want to sit down and talk to me about settling the case. We just spent $100,000 aside.
You tell Billy.
Or they could have mediated the case right at the beginning, but one of the lawyers said, nope, not gonna mediate.
Both Dale and I do that. We have private mediation work, and I am
They
shocked.
wait till they spend all their clients' money.
I am
Now we
shocked
wanna mediate.
at how many people don't take advantage of our services. I mean, at the end of a mediation, where people can spend, and I'm just saying on average, our mediations will cost maybe $10,000 total for both sides. We're done in a day, or in my brand with self-represented people, maybe 3-4 months. The average litigant goes through the system for 3 to 4 years. I'm on a case that I mediated on Monday. 5 years since filing, ain't done.
Attorneys are having to wait months to get into court. We can get into court in a week,
Right.
you know,
And get it done.
have things resolved. They can be done and on their way with their new significant other by the time they'd otherwise get to court.
What's that software you guys use for property settlements?
Robert Tyson?
Yeah, whatever.
Yeah.
I think it's really weird that people get so worked up about that.
It's basically an Excel spreadsheet,
Yeah.
you know? Yeah, exactly.
But it's the emotion, and that's what's different in family law, and why most people don't like what we do. I love it, because I'm happy to tell people what we do. That was my mama, she'd go, really? Are you nuts? Have you lost your mind?
I'm sure y'all have all heard, in criminal law, you deal with bad people on their best behavior. In family law, you deal with good people on their worst behavior. There's nobody meaner than someone in family law that wants to be mean.
I think Donald had it right, though. We got a big bunch of interesting psychological changes over the last 40 or 50 years.
Yes.
Weird stuff that's taking place in the world
Yes.
that has changed that spectrum. When Sheila and I were young lawyers, we had a couple of judges. One was from Mississippi, one was from Alabama. And they both had Confederate flags in their chamber. And we had judges saying weird stuff like, don't, wipe by the milk when you get the cow. And things like that. It's just crazy. And one judge yelled at a girl for wearing pantsuits instead of a dress. All that stuff was going on, and we were dealing with that. So that's, thank God that's sort of gone away. But now we have people who think they're smarter than they are, and they use AI, and they come in and lie. And it's that kind of thing. That whatever I get away with is okay. I just hate that when I see that. I tell our students, you're not getting out of here if you take that attitude with you. Because it's amazing how many people think becoming a lawyer means how to figure out how to get away with what you want to get away with.
You know when that slippery slope
Yeah.
showed up? When they aired the first episode of LA Law.
Oh, yeah.
Yeah.
Then you got away with, both lawyers got away with murder, and everyone, the public and other lawyers thought, yeah, you're supposed to be mean, and the clients thought, yeah, you're supposed to be like those lawyers. And I really noticed it when they aired that show.
You mean it wasn't The Godfather?
No, they said,
By the way, that was September 1986 because it was when I first started law school and everybody was addicted to that show.
no.
And here's a, we talk about practice pointers. Let your opponents be who they are. You don't have to get on their level. I mean, it doesn't work. When I have lawyers, I have a case that I had been on for a while, and the lawyer was uncivil toward me, got in my face, and you know what? I just said that. I didn't react. I didn't call the names back. I let the record speak for itself. And you know what? When you get on that level, that's when things get out of hand. So that then, Dale and I did the civility. Was that in the last comment that's on our civility handout?
The golden rule?
Yes.
There's like, it goes way back to ancient Egypt. You know, you talk about the golden rule, people think back and talk about Jesus. Go back to ancient Egypt, Greece, Rome, they all had some version of that, you know? And so, yeah, we did that.
As you would have, my mom and I used to watch Perry Mason. I think if you watch the reruns, they're civilized, good, hardworking lawyers.
At the end of the show, they're sitting around a table, Hamilton Berger, Perry Mason, Dallas Street, you know, they're all, even though Perry just beat his butt in court.
That was a good one. And by the way, I still watch those reruns. They come on Channel 14, right? And it's like you want to see how good lawyering is. And Perry never gets upset, and he's always got his little tie on. And Della's always up at 3 o'clock in the morning. Hey, Della, I need you to come with me because we got to go get this guy. I'll be there in pick up in 10 minutes. Okay.
All right, I shouldn't have been released TV. Go ahead.
What I love about, I know we're getting on topic, but this is too funny to not say. What I love about the whole idea of Hamilton Burger, did you realize his name's Hamburger?
Yes, yeah, Hamburger.
And I always thought Rod Soda used to be a partner with Larry Fry. And it could have been Hamburger, Soda, and Fry.
That's a good one. In your next life, Rod.
It was like my parents used to be strawberry farmers. And they used to have a ranch next to a guy named Ted Water. And they were referred to as the soda water ranch. All right, let's get back on track. Yes. Sheila, all right, now we can answer a lot of your questions about these last items. Sheila, talk to us about Rico versus Mitsubishi 2007 42 Calab 4 807.
Cases, my God.
Well, you know, one of the things that we learned as lawyers is you can say whatever you want to say, but what's your legal authority, right? So I tell my students, like, before you went to law school, somebody would ask you a question about something, you give them an answer. Okay. As lawyers, we have to give authority. Now, we don't always do that because it's hard. You gotta have the cases, you have the statutes, that's why we give you the information we give you about rules 8.3. And the purpose of this panel discussion was really good to see your visceral reaction to a fact pattern without really knowing the law. I mean, I'm not saying you guys didn't know all of this stuff, but most of us didn't know all of this stuff before we put this together. We put some numbers on it. So the case of Rico was a 2007 case. And what the offending party argued unsuccessfully was that there was a crime/fraud exception to this privilege rule. And the Supreme Court said not. Remember the hypothetical that we're talking about is the hypothetical number 7? That's what this comes under. So under that hypothetical, remember, you get the inadvertent transmission, and then you say, unless you dismiss, I'm taking you to the DA's office. I'm going to have criminal charges filed against you. So the reason that defense and argument failed is that at the end of the day, you can't threaten criminal prosecution. You can go do it if you think that's the proper thing to do. But he thought that the argument that would win would be, this is a crime fraud exception. You're committing fraud. This is a crime. I get to turn you in. And while our gut feeling tells us one thing, we have a case now, 2007, it's a number of years old, but it still stands for that legal proposition. So sometimes when you're in that situation, you think that's the right thing to do. I'm gonna contact the DA's office, I'm gonna contact the police, I'm gonna turn you in, because how dare you? We're supposed to be ethical people. Well, we have these rules, and part of this whole seminar that I love is, it's reporting. We know ethical problems happen, but it's the reporting of them. And how the state bar and the tribunals handle those kinds of ethical issues that lawyers are involved in. So, very important. You can't do what hypothetical 7 said without some potential criminal ramifications, without some state bar ramifications, and you can't justify the behaviors. Questions about that part?
What's interesting about it is the lawyer who got in trouble was like our petitioner, the person who reported it.
Yep.
He tried to argue 2018.040 CCP, the exception that says criminal or fraudulent behavior or communications between attorney and client are not privileged. But that Supreme Court decision said that section only applies in criminal prosecutions.
You know, if the attorney that reported this, if this attorney had really thought about Rule 4.4, he wouldn't have gotten himself in trouble. There's a comment on Rule 4.4 that's based on the Rico and Mitsubishi case. Comment number 1 says, if a lawyer determines this rule applies to a transmitted writing, and you remember, how far do you read on the email? You read until you figure out it's not for you.
Right.
Now, some of us, we may be slower on the uptake than others. You know, for me, it may take me through the second paragraph when I know that the lawyer's complicit before I realize it's not for me. For you, it may be the first line. I don't know. Somebody said a while ago, what if it said you're Fred and you're not Fred? Maybe so. But whenever you get to that point, it says, if the lawyer determines that this rule applies to a transmitted writing, the lawyer should return the writing to the sender, seek to reach an agreement with the sender regarding the disposition of the writing, or seek guidance from the tribunal.
Right.
So there's no reason that this lawyer couldn't bring the judge into it and say, you know, the two of us need to come talk to you, Judge.
Right.
And what should we do about this? But it seems to me that Rico solves the problem.
And we have things like protective orders, and I agree with what Dale had to say. You know, if you're in that dilemma, you go to your bench officer and you have this conversation off the record about how one protects that communication. Because, you know what, even if I know it's not for me, and I get this in text messages all the time, I don't know about you guys. Text message, when it comes in, there's just material. Now, I may not recognize the phone number, right? And I start reading. I can't tell you how many times I check a text message and find out that, I don't even know who it's from, because I didn't match the phone number because it's not Dear Sheila. And so those things do happen. So you can't, you know, there's no violation that I read the whole thing and maybe read it twice to make sure I got it clear. The question is, what do I do with that information, right? You don't have to get into a dilemma about, well, I only read 2 words, Your Honor. Well, maybe you should have stopped at the end of the first paragraph. That's not the issue. It's what you're gonna do with that stuff that you just learned.
I have a question. So in our scenario, even though the lawyer who received it would have known at some point it was not meant for him,
Yes.
it was CC'd to him, not sent to him.
Right.
So he already knows it's not sent to him. He's CC'd on it, so don't we normally, when we get to be CC'd to us, try to figure out, wait, why am I CC'd on this? Is there something about this email that I need to respond to? So wouldn't that be a legitimate reason to read the entire email?
I was looking at it saying that it was CC.
Yes, it did.
Not in Hypo 7.
Hypo 6, though.
Yeah, it was
At
at
no time, file for reduction, no time to disclose it as a second job, the lawyer mistakenly sends the opposing counsel the following email thread. It doesn't say he's CC'd, but I guess when you say email thread, you're thinking that's probably what it is.
A thread, exactly, exactly. And I think earlier on, I won't take up time. I won't take up, yeah.
Yeah.
So I'm whether or not that's what our hypothetical is, it's kind of something that occurs to me. What about when you are accidentally CC'd on something?
When you figure out it's not for you, you stop reading. I'm slower than most, and I would get through the second paragraph before I knew that.
But there's a difference between knowing it's not sent to you or meant for you versus knowing you were not meant to be CC'd on it.
Well, the rule is a lawyer receives a writing that was inadvertently sent or produced.
Right.
So whether it was CC, forwarded, or just emailed to, the lawyer received it.
And by the way, I recently, not the same situation, but I remember sending an email to a client, and another client responded and said, was this for me? It wasn't anything offensive, by the way. Because I had this rule, don't put it in writing if you can't defend it, right? So you don't talk for people to say stupid things in emails, but a client actually sent an email back saying, I don't think this was intended for me. It was just a document or form that I had to forward to my client. So when you put in that email address, sometimes inadvertently, right? Another email address might pop up. I've seen that happen.
Yes.
And that's the only way that I can explain it. And clearly this client, so when I put the first email address in, underneath like 3 or 4 maybe similar email addresses come up. And then you get to the part that you write. But I've seen that happen. But it happened to a client like twice, and I said, I'm so sorry, it wasn't anything offensive, but I've seen those kinds of things happen.
Okay, look at 8.3D, and that's something the petitioner's lawyer should have done. This rule does not authorize the disclosure of lawyer-client privilege information. You should have known at that point, you should have stopped. In this circumstance, what should petitioner's attorney have done to protect himself? Dale, can you address that issue?
Well, this is where I was saying, if he read 4.4 and then read 8.3, he could have avoided trouble. And this is where 8.3, I think, section, the comment number 6, the rule permits reporting to either the state bar or to a tribunal with jurisdiction to investigate such misconduct. And then, if he reported it to a tribunal under comment 7, that gives the tribunal the opportunity to figure out how to handle it. I think he satisfied his reporting rule when he's done that.
Going back to the RICO case, petitioner's lawyer was the one who got in trouble. What happened to him? He was removed from the case, and he was disciplined by the state bar. Even though he discovered evidence that the other side was manufacturing evidence, he was the one that got in trouble. The manufacturing attorneys for Mitsubishi got away with it because the Supreme Court agreed what they intercepted was attorney work product and it was privileged.
And this is something similar to, what was your name?
Donald,
Donald?
yes.
When you said that you were stunned by the removal of the word zealous, I was stunned to realize that ethical isn't necessarily morally right.
No good deed goes unpunished.
What you're ethically obligated to do doesn't necessarily make the outcome morally right.
Last hypothetical, which is a very short one, which we're going to put in the hands of Dale, because we're going to ask him what would he do. Assuming the facts of hypothetical 7, petitioner's attorney chooses to bring this matter to the attention of the judge. What does the judge do?
Well, the first question is, how did you bring it to the judge? And I think the thing is that since you had to disclose to the other attorney that you had inadvertently received this communication, and you're going to be bringing it to the judge, you don't bring it ex parte. You have to give the attorney that is subject to the possible misconduct the opportunity to be heard. So you have to give notice to the other side. You have to show up, go in chambers, sit down with the judge. I think that probably the answer that Rod just gave is probably the best solution for the judge, and that is to remove the attorney. But now the problem is, how does the judge deal with the fact that the judge is aware of something that the judge shouldn't be aware of? And it may be that this is the time for the judge to disqualify himself. Because now, the question is, can he be impartial? If he rules one way, one side's going to think that he was biased by this email. If he rules another way, the other side's going to think he was biased by the email. There's really nothing the judge can do. So I think at this point what you've got is you've lost the lawyer and you've probably lost the judge. I would certainly disqualify myself or recuse from that point.
Dale, even if you disqualify yourself, would this be an egregious matter that you would refer to the state bar?
Before the line happens?
But so far, there has been no crime committed. They've been contemplating this. This is akin to the person who says, well, that seemed like a good idea at the time, but by the time I thought my way through it, it's not such a good idea. And so it could well be that that's just the beginning of an email thread that winds up with the attorney saying, wait, we can't do this. You know, so I don't think so at this point. So far, they haven't done anything overtly unethical.
Could you call in though, Dale, and say, you
I'm sorry?
guys sit down here and you're not pulling your shit in this courtroom or something like that? Come to Jesus kind of.
Oh, absolutely. I've had lots of come to Jesus meetings with people. Absolutely.
But in this situation, you already know that through the discovery process, the lawyer was told by his client, remember I told you about X.
Yeah.
You told me not to.
Oh, so now we're going back to the beginning. The first, this is now coming through all the way through our hypos.
Yeah.
So at the very first, we know now that the lawyer knew about it at that point in time.
Right.
Oh, wow. But I'm not supposed to have the bit of information that tells me he knew about it at that point in time.
Exactly.
So I think at that point, I'm going to pick up the phone and call Seizure to find out what their recommendation is. Because, I mean, honestly, I have to, and that's really what Seizure's for. I mean, you go to them and you say, here's the situation that you don't even have to say I'm presented with. Hypothetically, consider this situation, and you get an ethical opinion from them. And they would give you some direction. Now, you can bank on their direction. So I would say at that point, that's what I would do.
Could you set an OSC? Could you set an OSC for these lawyers to come in and say, it's been brought to my attention?
Well,
and
yeah.
Then, then talk to them about recusing yourself or taking some kind of action.
Oh yeah, I would not address it with one attorney without both of them being there.
Yeah.
But I think the advice of get an opinion before you take that action. Because I don't know how many of you, I've done it a few times in my career where there's a hotline that you can call, the bar hotline. I got this issue, right? And they'll give you an opinion about what you should or shouldn't do. So I would want to get that opinion first before I had an OSC or call them in the chambers to find out what my ethical obligations are first.
Well, you might know that you have to recuse. You might know you have to take the attorney off the case. Question of do I have to report? But you still need to know that answer, and I think Sheila's right. You need to know that. You have to give people at least 15 days notice before you bring them, 21 days notice, before you can bring them in on an OSC. That gives you time to get that opinion. You contact the ethics advisory group and you ask them. And they ask 2 or 3 judges, for their ideas on it. And then they get back to you with a recommendation. These are your options, and then you take that and you file it away so that you can always rely on it. I took the responsible step of seeking an ethics opinion, and then I acted on it.
Interesting point about contact state law. A good friend of mine who is a good practitioner called and said, an attorney in my trial committed this egregious ethical violation. Under the rules, I'm supposed to report it to the tribunal. How do I do it? I said, should I do it ex parte? Do I bring a notice of motion? What do I do? I said, call the state bar hotline. He did. He called me back a few days later and said, and this was only 2 months ago. He said, they didn't know.
Well, see, now, at this point, we're talking about state bar hotline. I was talking about the judicial hotline. But still, I mean, I would not expect them to say, I don't know.
Yeah.
But even if they did say, I don't know, then I'm not gonna go very far wrong with whatever I do.
Yeah, that's right.
But many times though, Rod, I've seen
It
a
was their
situation
rule.
where they'll come back, they'll say, we'll get back to you in a few days. I mean, they may not have the answer right away, but I've had that situation where
Well,
they
they
will
did
get
with
back.
him too,
Wow,
and they didn't have the answer.
And they still didn't have the answer.
whoa,
Isn't that scary?
yeah,
It's their rule.
yeah.
All right. Any questions on the last hypothetical? The last portion of the program is going to be put on by Wendy. Again, it ties into the reporting requirements. Wendy Alderson, the trial consultant. Outside of the Coachella Valley, I am known as Mr. Alderson.
You should know that Wendy is probably one of the finest trial consultants in Southern California, probably in the state. She is really, really good.
In the Aaron Rodney case, she was the representative for PGA.
Thank you, Wendy.
Usually when people find that out, they're like, you were on the wrong side, but that sorority talk, I think I'm on the right side of it, right? So thank you for that,
All right, Wendy Alderson.
thank you.
Yeah, Wendy.
Okay, and for those of you who don't know us, thank you. For those of you who don't know us, Rod neglected to mention, we're married, that's why he is Mr. Alderson. Now you get it.
We've done a lot of focus groups and I've been mistaken for Mr. Alderson.
A lot where I have to tell people, if I accidentally call him hun, it's not sexual harassment of an employee, I'm allowed to do that. Hi. So, John asked me to speak today, and I was thinking, oh, ethics and jury selection, how exciting. There's a number of topics we could talk about, but one of the things that occurred to me was, this group has talked a lot about how you can violate your ethical obligations by failing to report, engaging in unethical activity or conduct and failing to report it. And they've talked about it in terms of fraud, deceit, things like that. I want to talk about it in terms of discrimination. Because we have a big issue in jury selection, as you're probably all aware, of using discriminatory criteria to select juries. So how many of you have done jury trials? Okay. And then how many have done criminal jury trials? Okay. I'm going to talk primarily about criminal jury trials because I think they're sexier. The hypotheticals are sexier, but this can apply to civil trials as well. As you know, you are not allowed to discriminate in jury selection against any cognizable group. So that's where we're going to start, and I want to give you a hypothetical. Rod said that was the last hypothetical, he lied. I've got some too. In this hypothetical, we are in a criminal case. The defendant is being tried for the murder of a gay man. The defense lawyer harbors the intent to exclude any gay men called into the jury box as potential jurors. The prosecutor, on the other hand, also believing in demographics, wants to make certain that gay men are on her jury. Okay? So here's my question to you that I want to throw out for a little bit of discussion first, and that is, if the defense lawyer attempts to use or uses or exercises peremptory challenges against all gay men in the jury, is that legal to do so?
We decided this morning that it was not.
You decided this morning it was not.
We
Great
talked about California.
Implicit bias.
Yeah, about bias. We talked about, what was the challenge?
Implicit bias.
The bats and wheelers challenges?
And then apparently California has a statute 231.7.
Got it right here. Oh my
And
God, sorry,
yeah,
my talk.
and
Thank you very much.
And talk, you're welcome, hon.
And yeah, please.
and talked
Beginning
about
and
that.
end, this bookend conversation.
Yeah, and talked about that very issue that you're talking
Uh-huh. And you decided it was not discrimination.
about. No, it was.
Oh, yeah, okay, good, good. I was like, uh-oh, because I'm gonna disagree. Okay, yes.
No, yeah.
Yes, all right, so we've already been through this, that yes, in fact, it would be discrimination because even though Batson and Wheeler initially had to do with, well, the Batson versus Kentucky had to do with race. It was a black man who was on trial, and the prosecutor was using all of the challenges to excuse the black jurors. And the court found that you cannot do that. I wanted to make this this example about a gay person because it's only much more recently that sexual orientation has become one of the cognizable groups.
But practically speaking, how are you going to know to begin with? You know, I can't even imagine asking a potential juror, "Are you gay? Or are you straight?"
That is a great question, which I was pondering last night when I could not sleep at 3 in the morning. And here's the thing. A couple of things. One is I was thinking about this in the context of you also don't want to target people that you think appear to be gay. So basically, I mean, you could ask a general question to the overall voir dire that says, have any of you ever been a victim of or harassed or assaulted as a result of a hate crime? Can you tell me a little bit about your situation? Have any of you ever been the subject of racial slurs? Just open it up. Have any of you been the victim of slurs or harassment or threats based on your sexual orientation? They can raise their hand. So you haven't asked them.
Questionnaire.
I'm sorry?
Could we be including this in our questionnaire?
Oh my God, John, I love you. Can I crawl over there and kiss you? Yes, juror questionnaires. Yeah, you could also be putting this in a questionnaire. If you do have a case like this, this might be an argument for asking the judge to hand out a prospective juror questionnaire before jury selection so that you can ask these and people can answer them in private.
Yes.
Because obviously answering something like, have you been a victim of sexual harassment or hate crimes based on your sexual orientation can be very uncomfortable for people to answer in an open court. So yeah, John, thanks for bringing that up, that you really would want to start out by requesting that the court give a questionnaire where you can ask a question. But again, getting to your point, Mr. Television, yeah, you don't want to say, you know, are you gay? But you can say things like, have you ever been a victim of threats or violence or anything based on your sexual orientation? And they can answer that without saying I'm gay. That actually kind of jumps ahead into some of the things I want to talk about.
You ask, are you homophobic? Please explain.
Are you homophobic? Please explain.
Wouldn't the opposing counsel object you're trying to precondition the jury? You're almost arguing your case by doing that. At least that's what I would have said.
I mean, they could argue that, but I think that what your answer is, look, this is an attack against a gay man, and you know, let me jump ahead. My next hypothetical was going to add that during this attack, the attacker was using gay slurs. Okay? So at that point, it's very relevant. It's very relevant whether or not a juror has had any experience in that.
I tried a hate crime just like what you're saying.
I'm sorry?
I tried a hate crime case in Pomona just on what you're just talking about.
Uh-huh.
And I don't think that issue ever came up at all.
So what did you do? Okay, which side were you on? You were defending. Okay, and what did you do with gay men on your jury?
I didn't even know if I had any gay men on my jury. I didn't care. I just wanted a juror that was going to listen to the evidence, follow the law, and keep an open mind till all the evidence had been presented.
You can be a district attorney.
Pardon me?
You can be a district attorney.
Well,
But
I was a defense lawyer, and they did what I said, and you know, I My guy got acquitted, the other guy is represented by a much more experienced criminal lawyer. His guy got convicted, and I think he focused more on what you're focusing, and I just focused on being fair and following the law and basing your verdict on the evidence.
And you know, I did a lot of criminal defense work. I did some federal jury trials, drug cases in LA federal, criminal federal court cases. I think that you're right in that perspective. I mean, what you want, the purpose of jury selection in voir dire is to make sure that people are gonna listen to the law, listen to the facts, and many lawyers will try to try their case by doing those things.
Right.
Are you gay? Even if there's a questionnaire, then that starts to put things in people's minds.
Right.
Because it really doesn't matter if a crime was committed. Whether
It's
it's black, white,
it's a
gay,
man, whether he was a gay man or straight, it doesn't matter.
exactly. Then we get to ask about people who may be transgender, and you got all these other things. Are you a member of organizations like gay organizations or other organizations that would target people in such a way? Plus, I think what that does, when they get to jury deliberations, then you've got this split already that happens. People say, oh, well, he's gay, or, you know, like, yeah.
I'm gonna respectfully disagree from the trial consultant point of view. I think that that's true sometimes. Here's when it's true. And by the way, you know, I only have 20 minutes to talk, so I can't get into my whole theory about jury selection. About my whole theory of jury selection, and that personally, I am not a big proponent of using demographics per se. I mean, not all women think alike. Not all African Americans think alike, not all Asians think alike, you know, they don't all think alike. However, that said, yes, you do want someone who can be fair and impartial, regardless of who the defendant is and who the victim is. But the thing about that is, when you are doing a jury selection, you need to know for each individual juror, what is the most dominant characteristic in that person. So for example, there will be plenty of gay men who are law-oriented first, that will look at something objectively like you guys are talking about, who will be fair and impartial and who can separate out their own emotions. But there will also be a lot of gay men who cannot. Okay? So, you know, if you are, to me, if you are doing a thorough voir dire, you do need to find out who those people are. For them, the most salient thing is, I have been a victim of hate crimes or assault or discrimination or anything, and they will relate to the victim, and you need to know who those people are. I think you need to ask those questions.
You know, Wendy, when I was doing criminal trials, I think I always had a questionnaire, and I always had both attorneys come in and work on the questionnaire. And we tried to ferret out the things that would, you know, there's some questions you ask that once one person realizes that gets them kicked out of the veneer, you just, you know, everybody's going to have the same issue, you know. So those kind of things that would appoint, that would be reluctant to bring up in a crowd, or things to try to get us an understanding of who these people are. And we had a whole bunch of questions that we'd ask them, let them fill them out before we ever had the actual voir dire in the courtroom. And that not only helped us to ferret out the problems, but it also gave the attorneys an idea of what they wanted to ask these people.
Right. And it also gives the opportunity for the jurors to indicate that it's private and they don't want it discussed in open court, which is incredibly important. You include in your preamble on the jury questionnaire that if any of these questions are personal and you want to discuss them in open court, just write private on the side, and if we need to do any follow-up, we can take it into chambers so that the rest of the jurors won't hear it. And I agree with you completely. And it's not only do you not want jurors to teach other jurors how to get picked, but you don't want to teach them the right answer. So when you're asking these questions, and especially jurors, John and I get into this all the time about if you correct if a juror says, yeah, I know one of John's questions that I love is, if you had to vote right now, what would you vote? And the answer is clearly not guilty because they are innocent until proven guilty. And so what if they say, I don't know how I would vote right now, I haven't heard the evidence. That's like an incorrect answer. But if you educate the first juror who says that, you've taught everybody else the answer and you haven't found out anything about the juror. Okay, that's getting away from my topic, so I'm gonna jump back to this. Those are all great things to bring up that.
Can I have your cookie?
Yes, you I knew you'd been sitting there staring at it, or I knew it. He is the cookie monster. Okay,
You
good.
can wise you up when you're asking stupid questions.
I'm sorry?
So you can wise a guy up when I'm asking stupid
Oh. So originally, when Batson Wheeler was decided, as I said, it had to do with race. That was extended to other cognizable groups such as gender and ethnicity, and then later on, much later on, sexual orientation. What's interesting is that Batson, when the courts in Batson originally focused on the issue being what was fair to the defendant. The defendant was Black. Is he entitled to representation of Black jurors on his jury?
your peers.
Is he? No?
Entitled?
Yeah. Yeah, not entitled to it. But what he is entitled to is to not having members of his cognizable class systematically excluded. So in other words, if a random culling of jurors seats 12 white jurors in the box, is he entitled to have Black people on the jury? No. But if there are Black people on the jury, he is entitled to the protection that they cannot be systematically excluded from the jury. So originally we're talking about the defendant's rights. Interestingly, subsequent case law that is built on Wheeler and Batson has focused on the juror's right. If you are a juror, it is discrimination to assume that you cannot do your job based on your membership in the cognizable class. That a juror has a right to serve on a jury and you cannot systematically exclude that person for being in a cognizable class. And then further laws started focusing also on the public, for the good of the public. That it erodes that if you can systematically exclude these protected cognizable groups that are protected not only in Batson and Wheeler, they're protected by Civil Rights Acts. I mean, they're a protected class. They have a right to not be excluded for who they are. I jumped ahead. Some of the, I think we've got some, are you doing the loopy guys? On PowerPoint 38, you have the California Code of Civil Procedure, CP section 2.1.5. It says the party shall not use peremptory challenge to remove a prospective juror on the basis of an assumption that the prospective juror is biased merely because of a characteristic listed or defined in section 111.35 of the Government Code or similar grounds. In 111.35, A, it says no person in the state of California shall, on the basis of sex, race, color, religion, ancestry, national origin, ethnic group identification, age, mental disability, physical disability, medical condition, genetic information, marital status, or sexual orientation, be unlawfully denied full and equal access to the benefits of, or be unlawfully subjected to discrimination under any program or activity that is conducted, operated, or administered by the state, etc.
What does that mean?
That means that the California Government Code says that those people are protected, and any what's the word they use? Any program or activity, which would include the judicial system, cannot discriminate on those grounds.
And when you say judicial system, you're talking about against a potential juror?
I'm talking, well, in the context of what I'm talking about right now, I'm talking about the officers of the court. That they cannot engage in discrimination by systematically excluding jurors who belong to any of these protected groups.
And one of those categories was their mental status or mental acuity or whatever?
So this is interesting that you bring this up. Very, very good. Yeah, according to this, yes.
I mean, that law is absurd.
According to that, when CCP 23.5 incorporates 11135, then yes, it does incorporate all this. Now, I will say that when I have gone back and looked at the case law specifically related to jury selection, it does not include, and in fact, there are some cases that are older that specifically state that, for example, marital status and age are not cognizable groups that are recognized with respect to whether or not you can excuse them for jury selection.
Would you say
But
that
again-
jurors have a right to serve as jurors if they want to?
Yeah.
Question?
Yes.
I don't know if this is what you're focusing on, but if you think, you're in court here, someone's stupid, too stupid to understand the case, is that disallowed by mental disability? I mean, what does that mean?
Great question.
That's exactly what I was getting at.
Yeah, that's what I'm thinking. I mean,
If you have a case that has technology that someone that is not relatively intelligent can understand, why in the world would you want someone, or not be able to exclude someone who did not have that mental capacity?
But it didn't say
So I
mental
think-
capacity, it said mental disability.
yeah, well, that's our question. What does that mean?
Disability?
Well, this doesn't say they can't serve it, it doesn't say you can't kick them, it says you can't kick them for that reason.
But that's the very reason that you can, it would seem to me, based upon doing this for 50, that's the very reason I would want to exclude them.
Okay,
If I
I'm
have-
going to jump ahead. I'm going to answer your question by jumping ahead.
You have, can I just ask a question? You have someone that's autistic, and they have the mental acuity or ability of a 10-year-old. That person can't serve on a jury,
Okay, so here's the answer to your question.
okay?
And again, I'm jumping ahead and it's going to ruin all my hypotheticals, but since I had 12 minutes and I'm not going to get to them anyway, what the hell?
Yeah, an hour and
So,
Yeah, you have plenty of time.
We can go anytime between 4 and 5.
Of course, the close people at 4
You
are
got
going to
I thought we were going till 4.
No,
At least.
We're going to 5. Oh, I see.
Take
Okay.
a
All right.
deep breath. This is it.
So here's, okay, in that case, I'm not going to answer your question yet. I'm going to ask you to save it.
Yeah.
Because I don't want to ignore it. It's a very good question, but I think when we go through this, I think I'm going to give you some answers as to how you deal with that. When you have a juror who may be mentally disabled and you want to get rid of them, doesn't mean you can't get rid of them. No, it means you can't get rid of them simply because they're a member of a cognizable group. So we're going to talk about ways of getting around that if you need to. Okay, so California Code of Civil Procedure, CCP 231.7, says a party shall not use a peremptory challenge to remove a prospective juror on the basis of the prospective juror's race, ethnicity, gender identity, sexual orientation, national origin, and religious affiliation, or the perceived membership of the prospective juror in any of those groups. So notice when you're looking at the Code of Civil Procedure specifically, it doesn't include all those things that were included in 11135. And admittedly, I think that's an issue because, as I said, I have seen recent case law where it specifically says that, for example, age and marital status are not considered cognizable groups under the Code of Civil Procedure with regard to jury selection. There's also Rule 8.4.1, which says prohibited discrimination, harassment, and retaliation. In representing a client or in terminating or refusing to accept the representation of any client. A lawyer shall not unlawfully harass or unlawfully discriminate against persons on the basis of any protected characteristics. Okay, so the answer to our hypothetical, and I guess you all figured it out this morning, was no. It is not legal for a defense lawyer to use peremptory challenges to systematically excuse, in our example, a gay man merely because of the fact that they are gay, and therefore they're a member of the protected cognizable class. So here's where we get to what I was just saying. That said, does that mean that the attorney cannot excuse gay men? This is what I'm posing to you. Does that mean that the attorney cannot excuse gay men? Why not?
Just not for that reason. You gotta have another reason.
Right. Right.
Maybe the peremptory challenges makes a pattern or shows a pattern, right?
Right.
So so if you are an attorney, and this is a concern to you, or in your case, you have a highly technical case, and you are concerned about someone who is not intelligent, who may be in a protected class like autistic or mentally disabled, how can you excuse somebody in a protected class? And it may be for reasons that are related to the protected class. How can you excuse them legally?
Void year.
Exactly. Exactly. See, so it's not that they're saying some of your concerns. I love your example about someone who may be mentally disabled. It's not that your concerns you have to keep the juror because they're a protected class. But what you need to find out is how is that juror going to be as a juror? How is that person going to be able to serve as a juror in the case? So in my hypothetical, I can't excuse someone just because they're gay. But if what my concern is, and that's what you have to do, you have to sit down and actually do the work. You know there's something about it that you're worried about. What is it? What is it you're worried about? I'm worried that they're going to identify with the gay victim. Okay, how? Why? Well, maybe they've been harassed in the past. Okay, so what you need to do is to do the work, do the voir dire, and to expose whatever opinions or feelings or attitudes or biases the juror may have, and those are the reasons. Those are the reasons you can excuse a juror. So you can't, again, you just can't look at them and say, well, because they're gay, I'm going to excuse them. So if you are making a case for, let's say somebody brings a Batson or real emotion against you, saying you've excused all the gay people in the jury, and so you have to disclose to the court, why did you do that? If you say, well, because they're gay, no good. That's violating their right as a protected class. But if you say that juror said that he had experienced anti-gay treatment in the past, or that juror had been a victim of bullying in school or violence because he was gay in the past, or that juror has a friend who was beat up for being gay, and that juror is very emotional, and it's a very particularly sensitive subject for them. So you just have to figure out what are the questions you need to ask that will get to the bias of
So they're implicit bias, right?
of each individual, not the class, but each person. What is the bias that you can articulate is the reason for you having excused the jurors? So here are just some examples of questions that you might want to be asking. As I said you may not want to say, who here is gay, but you can ask questions like, have any of you experienced anti-gay treatment or harassment or hate crimes in the past. And if somebody raises their hand, you can like further ask them. Going back again, John's recommendation that we use a questionnaire is, of course, the best idea. But if you don't get answers in your questionnaire, you need to follow up, you can do this. Or if you have a case where the judge is not allowing the questionnaire, as not all judges are as kind as Dale is, then you may have to ask them. But other questions might be, have you ever been a victim of bullying or abuse directed at you for being gay? Has anyone ever witnessed anyone being mistreated for being gay? If so, how did you feel about that? Again, you can ask that to non-gay jurors as well. And in fact, you should. And one of the reasons you should is so that you don't look like you're targeting gay jurors specifically with these questions anyway. Ask everybody if they've ever witnessed anyone being mistreated for being gay. Do you have friends? Everybody. Do you have friends or acquaintances who have been the victim of harassment or negative treatment for being gay? How fearful are you in general about being mistreated because you're gay, if someone has said that they are? Or how fearful are you about being harassed or assaulted? If you were to serve as a juror in this case and learn that the defendant used gay slurs while attacking a gay man, how might that color your view of the defendant? Or how might that color your view about the crime? How much do you think you might relate to or sympathize with the victim?
But once again, aren't you then educating the jury? You're arguing your case again. I just don't see how that's fair.
Aren't you asking this individually when you've got?
Yeah.
You mean back in the judge's chamber?
No, you can ask it.
But by doing that, you are totally tainting the entire jury panel, not only the 12 or 18 that are up there, but the whole group that's back here, because you're questioning about all this gay stuff. And you are clearly tainting the whole jury.
How are you
tainting? That's a fair jury process.
Okay. I don't think that it's tainting, and here's why, and then I want to hear what you have to say.
Okay.
To me, tainting is like when you're instructing someone as to what they should be thinking or what they should find. In these examples, all I'm doing is I'm giving some facts that they have probably learned in the summary that the judge has given. When the judge first comes in, and when the veneer first comes in, and the judge says, this is a case about this, you are merely giving them a fact in the case. You're not telling them what to think or which way to vote. So I don't see it as tainting, but you are saying this will be an issue in the case, and we want to know, is this something that is particularly offensive to you? Is this a kind of a case that you would find it difficult to be fair and impartial?
But I think by doing that, you are biasing the case in favor of you, or whatever you're attempting to elicit.
Well, it's the same thing that happens when somebody comes up with an excuse at the grant. I have childcare, I can't stay here past 3 o'clock.
Right.
Everybody out there knows now, you can't stay past 3 o'clock, you gotta think. It's very similar to that phenomenon, I think. I think Mr. Dan is right.
It's like I was saying earlier, whether or not there's a gay person or not, the crime was committed against a person.
Mm-hmm.
But you are painting that person as a gay person, and you're telling everybody in that jury box and room all of this gay stuff, when that shouldn't even be an issue.
But it's going to come out in the testimony that the
And that's why I'm saying, Judge, that's why I'm saying you're
gay
arguing
slurs.
your case. But there is no testimony yet. That's how come you're arguing your case. You're going to say what's going to come out, then she is telling the jury, this is the evidence, when that evidence hasn't even come out yet. Because how do you know what the real evidence is going to happen?
You're going to tell the jury, this is what the case is about.
Right.
This is about an alleged assault in which there were homophobic slurs that were made.
Right.
And those are things that they're going to, it's alleged, yeah, you're right, it's alleged.
It's alleged.
But you're going to clear out a lot of the people by having a questionnaire in the first place. When you get people on the stand, then you ask them about their answers to some of the questions on your questionnaire. The questionnaire is going to inform you as you're asking them questions. So,
but it
There is
starts
a
with
little
the
bit
judge,
of
but it starts
trying
with.
to thing with the jury anyway.
Pardon me?
There's always a little going over the edge, trying to get the jury to know about the facts of the case.
Right, but
I mean,
it starts
there's just always
with,
some of that going on.
it starts with the judge. I was recently called on a panel in India. 75 people, we sat in Judge Sterling's court. And the first thing he says is, here's what the case is about. Now, not all cases have gay areas, maybe they're just, but that's the first thing they say, because then it's, before we get to the questionnaires and the voir dire, it's like, if anybody has a problem with this kind of a case, let me know now, we'll let you go home. Or it's gonna last for a month, and if you can't be here. So I think those are just the introductory comments. To your point, when you're in the voir dire of that, I agree with you, it's not for purposes of trying your case. But sometimes people say things that lead you to ask them something that leads you to believe that maybe they're biased. Forget the fact that he's gay, he's biased for some reason. So it's a fine line. I've done probably 24 jury trials and I've seen it.
It's no different than if it's a child molest case. And at the very beginning, the jury is told the defendant is being charged with molesting a child under the age of 14, under the age of 12.
Okay.
You have to give the jury, and all the judges do, enough facts if there is a specific issue in the case that's a real hot button, where is reason to believe that some people will not be able to be fair and impartial. You don't wait and pick the jury and then find out that you've got all these people who, are like horrified by child abuse or they've been molested as children. And by the way, you would not believe how many people are molested as children.
No, I would believe it.
You set aside the gay stuff, though, you can say, you see, my client is black. Anybody have any issues? Or my client is Hispanic. Or my client is Asian. I mean, that comes up, that's an obvious appearance.
But
It's the
there's
same
a point.
kind of thing.
If you are able to subtly influence jurors to your side during voir dire, why wouldn't you do it?
Because I don't think it's fair that you do. That's not the purpose of a jury trial. The purpose of a jury trial is to base the evidence on the facts that comes out during the course of the trial and the law. It's not to bias them beforehand, so that before there's even one fact known, they're already on your side.
But
And yes, I understand that I do a lot of criminal law, and in criminal law, there's a presumption of innocence. I understand that because I'm a civil jury trial lawyer, but still, it just doesn't seem fair.
I know, but look at this one. You walk into court trying a case,
Yes,
dressed the way you are,
yes.
okay?
I'm gonna get thrown out with the judge.
No, forget the judge who didn't do it. But our job is to convince people, yes?
Yes.
I'm gonna walk in with my best clothing, I'm gonna walk in with my best demeanor, all for the purposes of convincing the jury that I'm right. Right? I mean, that's what we do. Now, the line, and everybody has their differences of opinion, and that's how you try cases, and that's okay. It's not a right or wrong way to do things. It's where you believe that line is, and that's where you get to have your line. Because nobody's going to agree that we should all do it a certain way.
No, I agree.
Because then we do AI, we don't need to show up in court, we just put the facts in.
You have to weigh that concern of fair and impartial jury against, what about a biased jury? They find out this is a gay man or whatever, and they go, I can't do this. We've had lots of people say they want to get off the jury because they don't like people that are in charge of the child molest. Again, they could never be fair.
Right.
You gotta ask them, you gotta tell.
Yeah, I mean, you can't know who can't be fair, given some of these hot buttons, unless you ask them.
But what you can ask them is, the defendant has been charged with child molestation of a 13-year-old child.
Mm-hmm.
If, based upon the evidence and the law, you find that he's guilty, would you be able to convict him? You can ask the questions based upon the law and the evidence that's produced during the trial. And I think,
And when you ask that question, what answer do you usually get?
well, hopefully you're gonna get a truthful one.
You're going to get your yes.
Not necessarily, I've been doing it for 50 years.
99%.
No, I disagree. I think you're gonna get, look, you're gonna get people who don't wanna be on a jury, and they're gonna say the cops always, I mean, one of the questions in personal injury cases, do you believe police officers always tell the truth? Well, no, if they say yes, the defense, one side's gonna kick them off. If they say no, they're always liars, the other side's gonna kick them off. You're hoping
Even
for
with
a
those
fair
folks,
and
I
impartial
think the
jury.
probability is right.
Pardon me?
But even with those fudge answers, well, the probability is less they're trained to be observers, and you get that kind of an answer.
I mean, I will tell you, as a defense lawyer, all I want is I want 12 people up there that's gonna listen to the evidence, base their decision on the law, and come back with a fair and just verdict based on those two things, the evidence and the law. That's what I want. I don't care whether they, as long as they follow the law and base their decision on the evidence, that's all I've ever wanted in 50 years and over 200 trials. I've won like 99% of my trials. And I think the verdicts have always been right.
And keep doing what you're doing.
Pardon me?
I said, and keep doing what you're doing, it's working for you.
Yeah, I mean, if that works for you, that is great. I tend to work, I get hired for really, challenging cases. You know, the Aaron Brockovich case, obviously, that was a big one. Should I not have asked any questions about what is your opinion about PG&E? That was a biggie. I mean, that was a big part of it. So, you know, in my opinion, I mean, that's great. In my opinion, two things. One is, I think you do need to know, if you want a fair and impartial juror, if you are lucky enough to get 12 people whose predominant characteristic is, I am smart, I can listen to the evidence without my emotions coming into play, then that's great. I have never seen 12 people in the box. You know, if you throw the first 12 in, I've never seen 12 of them that were all that way. I need to know who's not that way. And the people who are not that way are the people who have some sort of biases. They may not like a certain crime.
Right. But the worst question, isn't the worst question, can you be fair and impartial? Exactly. No, I couldn't possibly be. They never said it. That's right.
You know, I mean, yeah, that's
the difference between criminal work where you have to have 12, but doing what I did, I had to have 9.
That's the problem. That's the difference right there.
See, and that's a huge difference.
It is a huge difference. I agree.
Difference.
Maybe
That's a huge
that's why I
difference.
coached it the way I did, because I wanted 9 people that are going to follow the law and base their decision on the evidence.
And the other thing about doing criminal work is we have people. I'm gonna say it, John. I mean, basically, in general, the jurors are against us to begin with. Especially, I specialize in death penalty work.
Right.
And when you're doing death penalty work, and on the defense, sorry. I'm sorry, Pete. In defense, if jurors, they're given a questionnaire, and if they say they are against the death penalty and could never vote in favor of it because they are morally opposed to the death penalty, they are excluded right away.
You know what?
What is?
Blame me. That's got to be the most difficult thing in the world. I wouldn't want to be on a jury.
It is. But think about what the result is. The result means that every single person that comes in the box is pro-death penalty.
Yeah.
Those people, as a cognizable group, are more conviction prone. They are more punitive. So when they come to the penalty phase of the trial, they are more likely to sentence someone to death than if you really truly had a full complement of a fair cross-section of the community, which included people who are anti-death penalty. So, you say, hey, it's not fair that you taint the jury. You know what? That's great in the ideal world, but in my world, yeah, it's fair. It's fair. I mean, I need to ask those questions. I need to know who's particularly offended about my client, the crime, the whatever. I need to know those questions in order to help reduce the amount of anti-defendant bias, which is already there in that particular case, and make things a little bit more even playing field.
When you're dealing with criminal law, is it true that if you're going to take the case to trial as a district attorney, you've got a guilty person and you're going to get a guilty verdict? Do you get very many defense verdicts, John, where your client's acquitted? I don't know the answer.
I wouldn't say it's over 50%, but as charged.
As charged.
Yeah, there's something.
Pardon me?
As charged.
As charged. Everything that's listed on the complaint. Very rarely does it come back to everything. But yeah, that's a good question to ask, and it's hard. It's hard because there's a talking, it's not even implicit, it's an express bias.
Can I use our current case as an
Sure,
example?
sure.
Okay, so this
Can I just have one just little footnote because I think it's important. Wendy is incredible, okay? A jury consultant. I've been a lawyer for 45 years. I've never hired one, right? So the value of this, right? For a person who does nothing but analyze juries and how to help people. I did some criminal defense work, but I had clients who could afford to pay her fees. I don't know what they are, but they didn't have the money. But what I love about this is that she's taken this knowledge of all these years and given us, we're kind of shooting from the hips when we try cases, right? You go, oh, that guy doesn't look okay. Well, maybe he looks gay, or maybe he doesn't look okay. I mean, here's a person who has studied this and practiced it. So I appreciate her opinions, and by the way, Peter, I appreciate what you have to say as well, but the point is that everybody has different experiences.
True.
But this is coming from an expert who just does this. Wow.
So thank you for saying that. I really appreciate that. Let me tell you a little bit about my background, not to brag, but to follow up on, I know we're all going, I have 50 years experience doing this, I think, wait, what do I do? Here's what I do.
But I don't know anything about what you do, so I'm really,
So I'm gonna tell-
I'm loving listening to it.
Okay, great. So here's my background, quickly, I don't want to brag, I just want to tell you
Go ahead.
why I kind of think I know what I'm talking about. I have a 2 masters and a PhD from Berkeley in a PhD ABD from Berkeley in social psychology, specifically looking at jury dynamics and juror characteristics and how they correlate with voting tendencies in criminal and civil cases. And that was in I left grad school in 1985. I worked for federal defenders in San Diego for a couple of years as the jury research coordinator, where I interviewed every single juror for my entire office. And we had 16 attorneys. We probably had 16 cases go out a week. And when the jurors were done, had an excuse from the case, I would call them up and interview them for a couple of hours. I have literally talked to thousands, and I mean thousands of jurors, thousands of hours. I also do focus groups and mock trials. I've done zillions of those where we present a case to, usually I do them with 3 simultaneous juries, 10. And then I watch them, we have everything recorded. I watch them through one-way video glass, and we have everything recorded where I study and analyze them. I've been doing this for, my first volunteer work with the Contra Public Defender's Office was 50 years ago. So I have been doing this for 50 years. This is all I do. This is my passion. This is everything I read about. I love talking to jurors. I'm literally spending hours with them. Sometimes I'll end up meeting them for lunch afterwards. One of them is now a friend of mine, and I taught her ukulele, and she's in my ukulele group. I love what I do, and so that's where I'm coming from. Getting to your, when I said to you, what answer do you get to that question? Can you look at the evidence and analyze it and put your biases aside and be fair and impartial? Unless they want to get out of jury duty, most people say yes. Why do they say yes? I'm really getting off the ethics thing. Is this okay?
Fine.
I'll make this quick. Why do they say yes? Number one, it is a fact that most people, not us, we like to talk in front of people. Most people, normal people, have never spoken in front of a group larger than 4. Other than their family, and there they find themselves up there. Number 2, they are totally intimidated by the situation. The judge, the attorneys, the guy with the gun who's telling them, no, don't sit there, sit there. Okay? They are not real forthcoming when they're sitting up there. Number 3, they are subject to all of this social judgment based on anything they're saying. They know that the less they say, the less they get known, the less they get in trouble. Our cases recently, Judge Hawkins, he's so funny. He loves to be really nice to jurors. They love him. He's funny. He has this one little thing he does, at the beginning of every trial that puts everybody, they all know who's boss. And that is when a juror is late, he immediately tells his clerk, as if he's talking to her, but it's loud enough for everybody to hear. He says, all right, put that person down for a OFC and a $5,000 bail. Okay, and then he goes on. So all the jurors now know that he can just turn around and whisper to her, and you all of a sudden you have to show up in court, or you go to jail and you have $5,000 bail. So you don't say, no, I don't think I can be fair and impartial. You don't say it. So that's one reason. The second reason, and then I'm going to end there because I could go on for days, you probably already noticed. The second reason is, what is fair? What is fair? Can you be fair? How many of you think you're fair? Okay? Okay, now I'm a juror in a child molest trial.
You dirty unfair person?
Uh-huh.
A dirty unfair person?
I'm a juror in a child molest. No. But it does come in case. It does come in case. It does come in case, and I am really pro death penalty. I'm really pro death penalty, and can I be fair? Yeah, I can be fair. I can fry that guy. That would be a fair outcome to me. If he's guilty, fine. I don't need to listen to mitigation. But no, yeah, I can be fair. Okay, that question means nothing to me. When you ask a juror, can you be fair? That means nothing to me. Okay, for the last Malacca, I digress. I do want to digress one more thing. Because I think it's important. You asked the question to me and John about, are they really innocent? I can't remember what your question was.
Are they ever really
Are they ever really innocent?
And I'm not saying if you have 10, 12 charges, they're guilty of some crime. The question is, which crimes are they guilty of?
The point! Bingo! Okay, the magic duck comes down with the line, the word, bingo. Exactly. Exactly, but that's critical. That's not nothing. Like jurors say, or people say to me when they find out what I do, especially when they find out I do criminal defense, well, if they're guilty, why are they wasting everybody's time in trial? Because what are they guilty of? And sometimes it makes a huge difference. Right. So I want to throw out just one little example, because A, it's what John and I are living right now, and AJ. Closing arguments just ended on Thursday, and the jury will go out on Monday, and this is what we are living with. It is a case in which, you may remember, it was in the news in 2022, in which a man fatally stabbed both his wife and her lover in front of the Fairfield Hotel in Palm Desert. He is being charged with first-degree murder. We allege, and frankly, we really believe that it's manslaughter. So we didn't argue to the jury he didn't do it. I mean, he's on the surveillance video doing it. The poor jury had to watch it. There's no doubt that he did it. But the difference between him being found guilty on 2 counts of manslaughter is very, very, very different than if he will be found in 2 counts of first-degree murder. That's why we go to trial.
And the difference is in the penalty phase, is that right?
There's not a penalty phase because it's not special circumstances.
But
ultimately, there is a different penalty, and that's why it's important.
Okay.
Absolutely.
And it's real important. It's the difference between what years versus what years.
14 years for 2 manslaughters, 11 for one, and 1/3 the midterm for the other, plus 1 for the knife. So it ends up being 14.
Versus the 2 first degrees?
Versus lifelong possibility if they were both first degree.
Yeah. Did he actually just accidentally stab him each once?
manslaughter isn't accidental. That's a whole other story which has nothing to do with the ethics, so we can stay afterwards and talk about that, but I want to get off all that, but I hope that that
Well,
addresses.
good luck in your jury.
Hmm?
Good luck in your jury.
Thank you. All right, it is an interesting topic, so, let's see, can I come up with ethically, do we have to report anybody in those? Nope, better get back up to my notes, all right. All right, so when we last left this topic, we were talking about, if you do have a particular concern that may be primarily because the person is in the cognizable group, such as in a hate crime, if the victim is of a cognizable group, as a juror you may be concerned about that. What we determined is you cannot exclude them or excuse them simply for that. What you have to do, again, is you need to ask the legal and legitimate questions. You have to have legal and legitimate reasons for each individual, not the group. So, hopefully, if a person is completely truthful, their answers will lead to a cause challenge. I mean, if someone really has some difficulty. But if the person insists that they can nevertheless follow the law, which a lot of times they are rehabilitated to say by the other side that, well, yes, I mean, I do have these biases, but I could still follow the law. That's when you have to use your peremptory challenges. Those can be legitimate reasons. If you are challenged with a Batson Wheeler motion, even if the prosecution says they excuse that person, even though they said they could follow the law, you can legitimately say that they hesitated. They hesitated. They had to be rehabilitated to say that. And I think that there is still an implied bias there. If somebody says, do you think this? Not really. You can say. They may have indicated, no, they don't think that, but the bottom line is they hesitated. They clearly had something else going on there. Now it is critical. It's absolutely critical, and this is going to be one of the themes for the rest of my talk, is that you keep extensive, accurate notes about each and every juror. And when you're up there doing voir dire, that's really hard to do. I would suggest having a trial consultant because they are sensitive to the kinds of things that are going to make a difference here. But if you can't afford one, and I understand a lot of people can't, although some of us do pro bono, at least have someone there who is a really, really good note taker, who's really observant, who can write fast and write everything. And here's why. If you have to, okay, so there's two things that could go on. Either you are the person who is making the Batson Wheeler challenge, or you are the person defending it. If you are making the Batson challenge, you need to have notes that say things that are the reasons you aren't excusing that person. Sometimes I have seen really lame excuses, like someone is clearly taking off an ethnic group, and their reason for one of them was, well, she wore jeans to court, and I thought that was disrespectful to the system, okay? The reason you need great notes, if you're on either side, but even on the other side, is you need to kind of know how many other people were wearing jeans that didn't get excused. So like when I'm taking notes, as soon as someone goes and sits down, I write what I think is their age, ethnicity, gender. I write something about how they're dressed. I might write if there's something that stands out that they're doing that would either be a reason I might want to kick them later, or the reason somebody else might want to kick them. I'll make that note. The person kept reading the book throughout the voir dire, whatever. Kept looking at her phone. Kept falling asleep is a good one. Okay. You want to take extensive notes, not just the way they answer, or not just the words they use to answer the question, but you want to also take notes about the way they answer the question, okay? Are they thoughtful? Are they scattered? Do they understand? And this gets to your question about, can you excuse somebody who is mentally disabled? Well, not for being mentally disabled, but if you can articulate that I asked this person this question and they didn't understand, or they were unable to respond, that's a legitimate reason why someone can't serve as a juror.
By the way, your question to what Wendy wants, she wants the jurors to talk, which I've tried really hard to be good at and I'm not very good at. So we get the questionnaire information, and we should be asking them questions, but they ask questions like this, and then they express themselves. That's how we get the best information. And when he takes good notes, he reminds me every time, you have to get them talking.
Well, it's great she takes good notes. I'm lucky if I get down the right name and what juror they are.
You should see my notes. I write teeny tiny.
That's wonderful.
Micro notes because I write so much.
And pro bono work she does is for me.
Then you have a spreadsheet with every possible juror with our own little rating system. So we can sit there, go through who should stay, who should go, beyond the cause stuff,
And we did a spreadsheet in the order of the randomized list that's coming in, so we know who's coming up. If we kick this person will be next, so we can strategize as well. But alas and alack, we digress. So you want somebody, no matter what. I mean, I would argue you need someone who takes extensive notes, preferably a trial consultant, because they are trained to look for things that, for example, your paralegal would not necessarily look for. So I've been skipping around a lot and covering some things. The other reason you're going to want these notes is that if you're going to claim, like if someone's doing a Batson Wheeler against you, and they're saying you took this juror off because of this, if you're going to claim that you excused them for a given reason, you're going to need to be aware of how many other people fall in that category. So, for example, if you say, I excused that juror because he lives in that neighborhood where the crime was committed, but you only excuse the cognizable group guy that's in the area where the crime is committed, but you don't excuse any of the other people who also live in that area, then that the judge can find that that's not a legitimate reason that you're giving. So again, if you are going to make challenges that could appear to be targeting a cognizable group, you have to really try to apply your standards fairly to the entire panel consistently. Okay, I sort of come at what if you are, actually it's done kind of backwards. I've kind of been talking about if you're the prosecutor and you want to, if you're the defense attorney and you want to kick jurors who are gay in our hypothetical. Let's turn it around. If you're the prosecutor and you suspect that the defense is either going to try to exclude gay people from the jury, what can you do to prevent it? What kinds of things can you do to try to keep that from happening? We've really already talked about it, but
Rehabilitate, like you said, whatever reasons the defense might have set up for potentially using a peremptory on them, you can go up and identify a whole bunch of other people that have that fit that same category, or if they have articulated something that might be for cause outside the cognizable group, you can make an effort to try and demonstrate that, well, no, I really can't be fair. Notwithstanding what I said before, I can be fair now.
Understanding all that, can you still be fair and impartial? Mm-hmm. Oh, yes. Mm-hmm.
Yeah.
So that's a question I hate if it's somebody I'm trying to find out whether I want to eliminate them or not, excuse them or not. It's a question I love if it's somebody I'm trying to save for cause. You know, anytime someone says something that could get them kicked for cause, just try to bring them back to, but you could follow the law as the judge gives it to you, can't you? And they look over at the deputy with the gun, and the judge, they go, yeah, I'll do that. The other thing is, okay, so if you want to prevent it from happening, there's also just making this Batson-Wheeler challenge, right? So a lot of people think that you would make the Batson-Wheeler challenge at the end of the jury selection, before the jury's sworn in. I would recommend, and I'm not sure this is, I mean, to tell you the truth, I'm not sure that there's any rule whether or not you can do this. Some judges will say, no, you can't do it to the end. But I recommend do it as soon as you see it happening. Okay, so let's say I am in trial. There are 4 black jurors in the jury box, and the other side has just used her first 3 peremptory challenges to take all 3 of them off. I'm going to make my challenge right then and there. And here's why. Number 1, it's putting on notice, I'm watching. And the other thing is, when you go into chambers, and if the judge says, yep, that's a prima facie case, and says to her, tell me why, then you find out the reason she's giving for those jurors. So like in the case I have where the woman said, you know, the prosecutor said, because she was wearing blue jeans, and I thought it was disrespectful of the court. Okay, to be honest, I hadn't tallied up the number of blue jeans yet, because I wasn't anticipating that stupid one. Sorry. But once she said it, and the judge did say, okay, not at this point, but we'll bring it up again once the challenges have all been exercised, you can bet. I went back and I looked around at how many people were wearing blue jeans. So number 1, you're kind of in tune to what kind of questions, what kind of arguments that person's going to make. And what they're thinking. And number 2, it's kind of like letting them know that they are now under your watchful eye.
Well, if you protected that last black juror, because they're not gonna go after them now because they're on notice.
Exactly. All right. So at this point, and we are going to come back to this whole thing about ethics and reporting and all of that. So at this point, we talked about whether or not there was a Batson-Wheeler made, and basically once someone makes a Batson-Wheeler, 1 of 2 things are going to happen. The judge is either going to find that the attorney's challenges were in fact based on the fact that the prospective juror was a member of a protected class, and the judge will grant the motion, or 2, they're going to find out that the attorney had other legitimate reasons to excuse the juror or jurors, which had nothing to do with the mere fact of being in the protected class, and they will deny the Batson-Wheeler challenge. So let's circle back to our focus on ethics. Question. If the court grants the Batson-Wheeler challenge, and has the defense attorney and has found that the defense attorney in these hypotheticals violated the law and or the rules of professional responsibility, are you required to report for discrimination? When a discrimination against a cognizable group is against the law, it's against all of our rules, are you required to report? And I'm going to bring in my fellow sister panel members here. And from the judge's perspective, are you required to report?
Yes, absolutely. Canon 383 requires me to report, in this case, the violation of Rule 8.4.1, which is discrimination against a cognizable group. I'm bound to report it.
Don't you have to weigh the explanation though to see if that figures in
Yeah.
your decision?
Yes, but if I found it, well, and again, going back to the canon, I have to take appropriate action.
Right.
But in that case, if I have found that there is a Batson-Wheeler violation, I think I'm bound to report it.
What about immunity?
What immunity?
What immunity?
Let's call it judicial immunity.
Oh. I'm protecting myself by reporting it.
Right.
If you didn't
I got
report it.
Uh-huh.
Okay, Sheila, what about the attorney who witnesses it? I have brought a Batson Wheeler motion against somebody else, it's been granted, am I required to report it?
If it falls within the rule of 8.3 subsection A, remember, everything after that are exceptions.
You're not required because you're not a member of the bar.
Sorry?
You're not required to report because you're not a member of the bar. If you're not a member of the bar, they don't have a jurisdiction.
Oh, I didn't mean that me as a trial consultant, I meant me as a lawyer.
Right. That's how I took it.
We're fake, this is hypothetical,
So
so
to turn the lawyer in, and under 8.3 subsection A, if I believe that a crime was committed, I shall report it. You don't have any option. I shall. The exceptions, of course, are the maze, if you feel it's egregious enough, but under the basic rule, I have an obligation to report.
I used to be proud of the fact that I've never reported anybody for anything, but now I'm thinking maybe I made a mistake.
you can get in trouble.
I think we should find a few people to turn in, right?
I've got some suggestions.
I want to say something, well, it amuses me, but that doesn't, anyway. So Rod and I were talking about this morning, and I said, hey, if you have to go, because Don pointed out, I am not an attorney, nor do I play one on TV. I'm not a member of the bar. Typically, I am allowed at council table and to go to chambers to discuss anything that has to do with any of these challenges or jury selection issues. So I said to Rod, all right, here's one for you. What if the attorney goes into chambers, the Batson motion's been made against that attorney, give me your reasons for striking this individual, and the attorney says, because my trial consultant told me to. I don't know what happens, because I'm not bound by your ethical standards. So in other words, another reason to hire a trial consultant, because you can always blame it on us. But, no.
That's a great idea.
Okay, Rod, what about self-reporting? You have just done this.
Can I just say before you finish, it is such a wonderful, useful resource to have somebody like Wendy.
Absolutely.
Because she helps to look at people and to size them up, and I'm not that good at that. My view is, anybody can be a good juror unless they exclude themselves. You know, when they tell me something stupid, they gotta go.
Yeah.
Right.
Wendy can really size people up.
So my next life, I'm gonna be a defense attorney.
Picks up smart things and explains the significance of it, and it really helps a lot.
And a lot of, in jury selection, a lot of your peremptory challenges are obvious. You don't need me to know your first couple jury. They don't need me.
Psychologists say a lot of people give subconscious cues when they're lying. It might be the
Correct.
shift of their. Are you allowed to use that, and is that a valid reason?
Okay, so I do use that. I mean, that is part of what I will look at. Whether or not I would ever articulate if that's the reason. Yeah, I mean, yeah.
But that would be
It's not any.
that would be a place where you say they hesitated.
They hesitated.
Yeah.
One of the things I use a lot, again aside, is when I started doing this, demographics were the thing. They were the thing. All the attorneys would call me up and say, can you make me a little profile of who I want? They wanted me to say, do you want older, women, Hispanic, with this education? It's like, no. Everybody, I told you this before, everybody's different. And I will tell you honestly what my number, I have two criteria that are more important to me than anything else. I use a lot of other things, but the two things, one is analytical style. How does somebody approach the question asked of them? It's not what they say, it's how they answer the question. How did they analyze the question and come out with the particular formula that they said? And that's why I love hearing John say, ask open-ended questions, because I've been working on it for, 15 years, like, opinion that I don't get anybody yes, no answer. I want to hear how somebody answers. And the other thing is what I call locus of control. And that is, if someone has an internal locus of control, they are very self-driven, they accept responsibility, they believe others are responsible for their own behavior, versus an external locus of control. You all know them. They are playing the victim. Oh, I hate my job. My boss is always mean to me. You know, I keep getting written up for being late. Blah, blah. They have an external locus of control where it's everybody else's fault. That is like gold in jury selection. So, I mean, frankly, I love the question, how do you like your job? And I'll tell like a new attorney who works with me, you know, what do you want me to ask? Well, first ask them how they like their job. Like, what? But seriously, I really learn a lot the minute someone tells me how they like, what they think about their job. But anyway, did I skip you on the self-report, my dear?
It's okay, what was the question?
I don't know.
How do you like
The answer is,
How do you like your job?
Federal Code 6068 makes it clear that if a judge reports you, you better report yourself.
Yeah, but there's also that possibility of 8.3, that if you're wrong, that you could be disciplined.
If you're wrong about reporting yourself?
No.
No. Reporting others.
Oh,
I would
reporting
say
others.
the criminal lawyer practice is more civilized than the civil practice
Uh-huh.
or the family law practice.
Oh, absolutely.
It's just weird.
I think you guys
I
are
don't know
missing.
any, I mean, we know some people that like to stay away from, but lying and cheating and that kind of stuff.
Yep.
And you'll never see a jury consultant in family law because I'm the jury.
All right, so this time it is the last hypothetical. So we just discussed whether or not you had the court had a report, the other attorney had a report, or attorney self-report. Should the judge find that the attorney in the hypothetical did in fact violate the law and the rules of professional responsibility? So here's a question for you. What if the the court, on the other hand, denies the Wheeler motion, finding that there's a lack of evidence that the defense attorney in these hypotheticals has systematically discriminated against a cognizable group? But you believe the judge is wrong. You believe that clearly there was discrimination going on. Maybe the lawyer, the slick talking lawyer, got in the blue jean thing and the judge bought it, or at least it wasn't enough evidence to find the discrimination. But you think that there's enough evidence for discrimination. Must you report it? Look at your other attorney.
No. No.
Nope. You never would?
Well, under those circumstances, under those facts, I would not.
Okay. What circumstances would you?
It would have to be pretty egregious. I mean, it would have to be, some major cognizable group, like blacks or gay folks, or, people who, it's an obvious bias that they're trying to send a message. Other than that, it's just human nature, is what people do.
If it's bad enough for the attorney to report the other attorney, they may also turn around and report me to the CJP.
Right? Right.
That's your own mess.
This would be a dumb question, but just end on a funny note. Would you self-report yourself?
Of course not, I popped my buttons, I was able to avoid it.
You get out of that courtroom real quick, all right?
All right. That concludes our discussion on this. Are there any questions? Thank you.
Not related to what you've been talking about, but this morning we were talking about bias.
I'm sorry, Donald, can you speak up just a little bit?
This morning when we were talking about bias, and we did touch on jury selection. And somebody, I don't remember who was, asked about the use of artificial intelligence in jury selection.
Uh-huh,
Is that a tool that is something you use?
no,
Okay.
and that's just me.
But is this something that is injecting itself into the process? That you know of?
Okay, so this is a personal opinion, not a true answer. I mean, the truth, like, some people use it. Some people use it, I do not. I mean, I remember even when that program came out, what was it called? The jury thing that you had on your iPad?
Yeah, people, yeah.
You know, where you could like put in the jurors' names and all of their social media would come up and that kind of thing. AI, I would find even more dangerous because I don't think it's always accurate. I also think it's a matter of garbage in, garbage out. And at this point, I think that the garbage in those kinds of programs is very demographically driven. And again, I don't usually go by demographics. Now, when I say usually, I mean, there are occasions when you have nothing else. I've done work in federal court, lots of cases in San Diego federal court where we literally have judges that can conduct an entire voir dire in 15 minutes, where I know nothing about the jurors, and sometimes I just have to use what I know. And it's not enough, but I got no choice. And so sometimes I will have to rely on sort of things like that. But basically, I don't think that the AI can possibly detect the things I'm looking for.
The obvious stuff, I mean, there's background check apps that you could use, like, you know, you have a gang case and somebody says, I don't know anything about it, you show on a background thing, symbols with guns and stuff like that. You can find out some stuff like that, but I don't think it's that useful as far as analysis. I think it's just finding strange things in a background check.
Oh, you know, it's funny, just like you believe you only need answers to certain questions, as much as I want to know everything I possibly can, the fact of the matter is, because here's some things I don't care about, that people used to care about. I was hired to do a case once that included, we got the juror list ahead of time, I drove by every single juror's house, and I looked at their bumper stickers, and whether they had toys in the yard, how well they cut their grass, and blah, 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 blah. And it cost my clients thousands and thousands of dollars for me to spend that many days driving by everybody's house in San Diego County. Did I use one piece of that information? No, I did not, because what I got from the juror, I got in the courtroom. I got by doing this. I'm just one of those open-ended questions, thank you. I am just one of those people who doesn't use AI. I'm terrified of AI. I also love some of the AI stuff. Wow. But no, I don't use it in my profession whatsoever. A lot of what I do has to do with being an empath, and I need to be right there with the person.
Okay, thank you.
Any other questions? No?
Those who fancy ourselves as great cross-examiners have trouble with this open-ended questions. But Wendy is the greatest, and I'm telling you, it's just such a wonderful resource to be able to call upon. And I appreciate Rod and Wendy both, because they're just both good people in there. Very helpful. And of course, Gail and Sheila are great people, and I'm so proud that they would come down and do this. They're looking for some mediation work in the family law business. Seems to me like it'd be hard to mediate in family law because people just hate each other.
Well, those are the folks that we want to send back to the court.
Good. Good. All right, Rod, you got more? You got more, Rod?
No, we're done.
You're the moderator.
Thank you. Tomorrow we're going to do practice development, then we're going to do technology in the courtroom. The judge that's coming down is an expert in technology, is going to help us with the technology stuff. The Rams are on at 3, so we'll be good.
And also, Judge Velasquez, who's going to be doing the technology, is going to be talking about AI in the courtroom.
Good,
so
good.
You'll be getting a little bit of that.
And Irene will not have lunch for you, but you have a little.
I'll have pastry and